Yeah. I may be excused, my lord. Item number 29. My lord, Justice Das is the member of the appeal committee.
Yes, we are aware.
We'll go to
We are aware of.
May I pardon to mention,
I
my
have
lord,
accused.
the petitioner challenges the method of calculation made by the Honorable Claim Commission. We approached the Honorable Supreme Court and Supreme Court directed to file writ petition. Accordingly, writ petition has been filed, Millers, and we have deposited 150 crores before this Honorable Court. And your Lordship, compensation amount is lying with this Honorable Court. Lordship may I have mentioned for disposal of this writ petition, Millers.
Yeah.
Lordship, any date, Millers, your Lordship can.
Yeah. Petition challenge auction notice. Auction date is fixed to 31st.
Into situation matter matter. Situation matter. Surface action. The grant is fixed today for e-auction. The petitioner's land along with residential.
It's all right. Give your memo, it will come.
Pardon to make a mention, my lord. Criminal appeal. The present appeal had custody more than 10 years.
So the item 34 kindly pray for an adjournment, Lordship.
Now, when the matter reaches, please make the mention. Yes.
Item 49. Notice was issued and state was supposed to file counterfeit in that matter.
Wait, we'll see that when the matter reaches.
Weekly list item number 1.
Petitioner filed writ application challenging the order passed by the Apportionment number 3 by Annexure 11, page 44. They have rejected the prayer of the petitioner to include his service as in pensionable job. Earlier, the petitioner has filed a writ petition before this Honorable Court in WBC.
Direction was there for filing a representation for consideration of representation, and that representation has already been disposed of. So how do you say that the judgment of Anand Das versus State is applicable to you?
Because they have appointed after the amendment.
Who? No.
The Anand Das man.
Kindly read. Their whole recruitment process is before 1/1/2005.
Right.
All right.
But appointment was made after
So
the
since
amendment.
the advertisement was there, the analogy given by the Supreme Court, even, which has been confirmed. Analogy is that a candidate comes for recruitment, keeping in view the benefit and the perks or service conditions.
Petitioner was appear in the selection list, and the list was prepared in the 1999. Since 99, she is working.
When the recruitment process starts, the candidate make application on the basis of the condition of service. Had the condition of service then in 1992 rules would have been a pensionable establishment, the petitioner would not have applied for it. That is how the court gave the analogy that by the time the advertisement was there, the process of recruitment was initiated, the written test was taken. By then, the establishment was pensionable.
The petitioner was selected in the year 1999.
No.
And he was in the list.
List of Mulia, that was a temporary one. And master roll, regular master roll, he came only in 2006.
Yes,
so by then the notification was already there. So that is how you have to now say how the decision is applicable to you.
My case is, though the petitioner was the Ananda's case was regularly appointed after the Amendment Act. So my case should be considered as per the Ananda's case.
Ananda's case, just come to that order which you are challenging.
Page 45.
Annexure 11.
Please come to paragraph number 2.
Yes.
Please place it that.
The petitioner is Ashok Kumar Swami, the present senior grade diarist, and senior Sunakar Malik at present junior Jamadar filed WPC number such and such in this Honorable Court, paying to inclusion for their service under their General Provident Fund of Odisha, such and such, and an amendment to the Odisha Civil Service Pension Rule 92 was made on 17/9/2005.
So this particular date you keep in mind.
My
Okay,
lord.
this is very important date.
My lord.
Okay, now you carry forward. Yes. Carry on, carry on.
My lord,
Yes, please.
stating therein that all person appointed under the government of Orissa with effect on 1/1/2005 shall not be eligible for pension and shall be.
So just keep
My lord.
pause for a moment.
My lord.
So even though this this was held in on 17/9/2005, that whosoever has been appointed with
1/1.
effect from 1/1/2005
Right.
will not be eligible. But these two dates are very relevant. 1/1/2005 and
As per the-
17/9/2005, right? So this Anandas or this person who has this Tushar Mukherjee
My lord.
case, they were regularized during this particular period.
Right.
Whereas you were regularized in 2006. So that is the basic difference between you and Anandas or that Tushar Mukherjee. Had you been, your appointment would have been regularized in between
No,
17/9/2005.
2006.
So your case would have been covered either by Anandas or this Tushar Mukherjee.
My case is though the some person has included in the merit list who has not appeared in the test or anything. They have
That would
regularized
have been
prior to the
that would have been a different cause of action. Now your FRAR, as such, we have to take into account that when your particular post has been, you are regularized in that particular post.
Right.
So that was obviously after 17/9/2005.
Right.
So the two cases which you have mentioned in your writ petition,
Right.
that is Anand Das and this Tushar Mukherjee, they were regularized in between that date 1/1/2005 so to 17/9. So that is how he has distinguished your case from the other two.
Right. Yes, though my case is only though some outsider have entry in the merit list, my case has
Because
not.
once you see what would happen, your case is of 2006.
Right.
So once such a relief is granted, then all the persons, even they, irrespective of what has happened whenever they are appointed, they will now come forward to be included in that. That is not the thing. You have been given something else. For you, the provision of contributory pension has been taken care of. So that is a totally different for those. So a cut-off date has been fixed. Okay, for those particular persons who were in between that 1/1/2005 and 17/9/2005, for them, this court as well as the Honorable Supreme Court has taken care of them and said that no, even it came into, since it came into force on 17/9, but it is making an antedated one.
1/1.
Yes.
1/1/2005.
No, but the date when it was, you see, 17/9 ଆସିକିନି ତାକୁ back କରିଦେଲେ, antedated କରିଦେଲେ। ତା ଭିତରେ ସେମାନେ କହୁଛନ୍ତି ଯେ ଆମେ ତ ଆ ଭିତରେ ଇଏ କଲୁ ତ ତମେ antedated କେମିତି କରିବ? So that was the reason why the relief was granted, mainly basing on that. So how you, if your case is accepted, then everybody, even a person who has come in the service in 2000, let us say 16, 17, he will come up and claim that.
So petitioner has appeared in interview and selected, and the merit list was prepared, and in the merit list petition.
The question is, unless you are regularized, is there any question of getting pension?
Yes, ma'am.
So the date is relevant is when you are getting. So that is the problem. All right. Okay. We'll pass the order. Yeah. Next.
Item 2.
Here in this case, the petitioner is a landowner has given lease to two persons for business. My lord.
What is your prayer in this?
Prayer, my lord, as per the agreement, by the time the land has been acquired by the railway department, after leasing the land, my lord, the lessor was constructed a house. As per the agreement, if it will
Where
be
is your representation pending?
representation pending before the collector, my lord, Annexure 6.
That is to be disposed of. Like you can like 2/4/2024 representation. ठीक है लिखियो एप्रिल लूट करेंगे एथि पे रिप्रेजेंटेशन देइतला so and so and it is pending since so and so. So direction there it is to be disposed of within 3 months from the date of production of the certified copy of the order है ना? And order be communicated to the petitioner. That's the usual order. Yes.
I think my lord,
Huh?
similar.
Similar. ଆଉ ସେମିତି matter ଅଛି ତ?
Different railway party
My
ଅଛି
lord, I am appearing for 1 and 2.
It's all right. Council को ना लिखी देवे.
DSJ along with my.
Please give your name and for whom you are appearing so that you will mention it.
disposal.
That is to be representation is to be disposed of within 3 months from the date of production of the certified copy and order is to be communicated to the petitioner. Yes.
Item 3.
Application checking direction to the opposite party number 3 pending the representation annexure 3 page number 18, my lord.
Annexure 3 is the representation.
Yes, my lord.
Okay. Same order.
Yes.
Item number 2.
Yes.
Is item number 2, my lord?
Item number 2 is disposed of, Mr. You are for whom?
Central government.
Union of
didn't serve the copy. That's Mr. B.K. Padi might have there.
Yeah. Central government. Somebody is there, Mr. Central Government Council. He
is my associate, Mr. B.K. Padi, Mr.
So we have directed Mr. Parit just to dispose of the representation within 3 months and communicate the order from the that would be effective from the date of production of the certified copy and that order is to be communicated to the petitioner. That's all we have stated.
My lord, only then may be directed to serve a copy. They didn't serve the copy. Otherwise you cannot communicate the department.
Okay. See, copy, let a copy of this one. So, hard for that. अच्छा. There was already direction.
On 19/6, there is already
Why?
a direction.
Yes, my
Yes.
Why have you again rushed to this call?
Same
It should
order.
come only after the outcome, no?
Same order, my lord. As per annexure 4, my lord.
So it is only there only to be reminded.
Yes, ma'am.
You know, is there any time limit fixed on that
Yes,
dispose of this one? So within 3 months, so that 3 months is not yet over.
It is only on 19/6.
Take down. So let's on the prayer is this. It appears that the petitioner earlier approached this court in this petitioner, somebody else on our case is Saudamini Raut Velikotas. ठीक है 3 months ये करते हैं ना तब देखिए लिखिए जो prayer था वो देखिए 3 months है more. Okay. Next.
3, 4, 5, same, my lord.
3, 4, 5.
5 and 8, my lord.
8. Okay.
Yes.
8.
Item number 6.
Item number 6.
Item 6, 7, 9, 10. These are all state matters where we have challenged the order of the administrative tribunal, granting third RSCP in favor of a person. According to us,
what is your ground?
My lord, ground is it's not admissible at all. Because, my lord, may I pray, my lord, to kindly take up item number 10, please.
So just see the first paragraph of your writ petition, what you have stated. of admission, no writ can be disposed of. We are disposing of Delhi.
My lords, it can be not.
So,
I don't
so
think, but
did
here,
your is it your contention that the additional standing counsel was not at all hard? When it is written like that, do you mean to say that if you mean to say that you could have filed a petition that I have not been hard, but it has been wrongly reflected when the matter is still fresh in the mind of the court? You
no,
have not done that.
we have not. It's
So
not been.
now in 2019 that order was passed. You are coming to 2024, sir. We are not hard. When the order itself shows that you have been hard and the
No.
order was passed,
It's
and that
there.
is based on the earlier orders. A batch of cases have been disposed of. That judgment was confirmed by this court in the High Court. So what is there?
Now, my lord, they are pending in Supreme Court and stay has been
It's
granted.
all right. You also challenge that.
My lord, only, my lord, I will I have subject to my lord's acceptance.
It's all right.
Subject to my lord's acceptance, I will only submit 3 lines.
Yes.
Now, there is a notification, my lord knows, 6/2/2013, which gives rise to the entitlement of the very RSCP. Now, I will place that 6/2/2013
Will not go
notification
to that.
and I
That
will
order
commence.
has been, its matter is subjudiced in the Supreme Court.
No.
The not like are the Land and Council for the State, Land Council for the State. In this writ petition, prayer has been made like so and so. The very first ground, the ground that has been taken by the in this writ petition is that the impugned order dated 18/2/2019 was passed by the Land and Orissa Administrative Tribunal, Bhubaneswar bench, Bhubaneswar in OA number so and so, whereunder the Land and Tribunal at the stage of admission and without affording any opportunity to the state petitioners allowed the original application filed by the opposite party. On perusal of the impugned order, we find that the Land and Standing Council was given opportunity of hearing, and thereafter the Land and Tribunal, after taking into account the ratio decided in so and so, the judgment of this court passed in so and so, and in so and so, allowed the original application. The Land and Council for the state submitted that the order passed by this court is under challenge before the Honorable Supreme Court. Be that as it may, since the opportunity of hearing has been granted to the petitioner and impugned order has been passed, we find no illegality, impropriety in the order. We are not inclined. अच्छा put a line लिख दियो. If in fact the Land and Standing Council was not hard, but the order reflects like it was open to the Standing Council to file an appropriate application to bring it to the notice of the concerned presiding officer that he was not hard, but it was wrongly reflected that he was. The same having not been done, and since in the meantime more than 5 years have already passed, and similar matters, and relying on the batch cases, similar orders have been passed. We are not inclined to entertain this, so on, so accordingly dismissed. Yes, what are the other applications?
No, no, the 7, 9, 10.
7.
But OA numbers will be different.
Yes, sure. 7, 9. Yeah.
Yes. 11 to 14.
14. 11, 12, 13, 14.
May is
Just
6.
Item number 11, 10, 11 and 12. The orders have been passed by which member?
Somebody is asking item 11.
And Annexure 7, you see, 16600. WPC 16600, Annexure 7.
16600.
You have referred to Annexure 7. Yes.
Acting chairman, just my lord, may not
Here we see the 10.
So, in how many matters here?
Item 10 also, my lord.
10, 11, 12.
Then I'll have to check, ma'am.
Kindly check it.
10, 11, then my lord, the impugned order is not by
Impugned order is by different member. Different member or so that order has only been
Relayed.
relayed. That means the earlier batch order was passed by BKS.
Yes, that's.
may submit 2 lines subject to my lord's. My lord, identical matter. I was the admin counsel.
Yeah.
Before Honorable Court number 1. My lord, I satisfied, and if my lord will permit me, I can also satisfy here that they were not entitled.
All right.
In principle,
Please.
they are not entitled.
Yes,
Delays should not
item number 15. Come. Yes. Next.
Item 15.
Nobody is there. Password.
Item 16.
Password. Item 16.
Sorry.
Which item?
Item 15.
15. 15.
15. 15. May I please, madam? My lord, challenging the order of dismissal dated 24 June 2024, passed by the Learned Tribunal, Learned CAT Court of Orissa, in OA number 398 of 18. The petitioner is before my lord. In the case of petitioner before my lord, that he and private opposite party number 5, they had appeared for a selection promotion to the post of filter operator grade 3 my lord in the year 2004 my lord. Though selection was completed, panel prepare order of promotion effected. But later on, he and another one, Mr. S.K. Mishra, they came to know that the private opposite party is a failed candidate, but not only he allowed to be passed in the
Please
selection.
come to paragraph number 12.
Mine.
Please read it.
Be that as it may, undisputedly, promotion of both the applicant as well as response 6 to the post of technical grade 3 was issued on 31st May 2005. Grade 2 on 18/6/2007 and grade 1 on 25/11/2009. For the first time, the applicant submitted his representation only on 30th January 2017, alleging illegality or irregularity.
So almost after 12 years.
Mine.
So that was the main ground
Mine.
that you have been named as a fence sitter. In the operative part of the order, you have been named, come to paragraph number 19.
Mine.
Please read it.
It is settled law that fence-sitter cannot be allowed to raise the dispute or challenge the validity of order after its conclusion. My lord, I am not a fence-sitter.
You are there.
They are mine.
In suppose something has been happened on
Mine.
2005.
Mine.
You sat silently, nothing, no complaint.
Mine.
Again, another promotion was given. That paragraph which we are referring to.
Mine. Grade 2 promotion and grade 1 promotion also.
Okay, so you remained silent. All on a sudden, you rose from a deep slumber and filed a representation in 2017.
May
So-
I pray, my lord?
Yes.
My lord, may kindly give a glance. Page 26 of my requisition. The information supplied to me under RTR.
No. When the information was supplied, that is not relevant.
So when did you apply for that?
My
You
lord,
applied for in 2005 and you were given in 2017.
No, madam.
Then,
My lord, my submission before my lord that I have filed a written notice relying upon two decisions of Honorable Apex Court in my support.
he has relied upon so many decisions
So,
of
well,
the Apex
this-
Court that on
The-
the
my
ground of delay and laches, a party cannot be given relief.
My lord, the
So you are an indolent, sir. You are not a vigilant.
my lord,
When a right
it
is
was
going
law-
to be under
my lord,
prejudice,
at that point of time, there was no scope to know that he has secured.
how can
less
it be
than-
offset right now after
My lord, may I pray, my lord, I have relied upon two decisions while taking a final decision on my MA. The London Tribunal has not taken the same into consideration, man. That
You
is
see, why it is time without number, it is stated that even before this court also, writ petition, if you are gross delay, laches is there on the, no relief can be granted. Why it is stated that? Because by the time much water may be flown under the breeze. So you cannot take back the clock to that position. You are there, you are, according to you are affected right from 2005. Is it not it?
my lord,
You remained silent.
Right.
2007,
Yes,
another
yes,
promotion,
yes,
remained
yes,
silent.
right, right.
So,
But I have relied upon two decisions of the Honorable Apex Court. May I pray, my lord, to place in similar situations, the Honorable Apex Court has decided the law, man.
yes.
And
we'll deal with that.
both decisions I have quoted at my
Yes, yes, a part of high.
page 44, man.
You're relying upon CORAM, no?
No, my lord.
Then?
I have relied upon the decision of Honorable Apex Court rendered in case of Ajit Kumar Bhuiyan and others versus Devadi Das and others, my lord. That is, and another decision
Condoning the delay of even years.
Mile.
Yes, that is CORAM is also there.
You also kindly give a glance the judgment of Honorable Apex Court. Para 28 and 29 of the judgment.
Which paragraph? Which paragraph?
Para 28, my lord. 28 and 29. That happened, that is one more reason for coming to the conclusion that the division bench of High Court was in error in saving respondent number 1 on the premises that the writ petition suffered from delay and lapses. In fact, the association had submitted representation to the then CM. Going by the nature of allegation, the CM, the Chief Minister, rightly acted thereupon and refer the matter to a committee which after examining the matter had also given its report stating that the portion of respondent number 1 was against the rules. This provides reasonable explanation for delay if any. We are of the opinion that it was virtually a case of fraud, at least on 3 counts. Firstly, by creating a scattered post of executive engineer only for respondent 1 and giving him that post when he was much junior to many others. Second, encadrement of respondent 1 as executive engineer by showing that there were 13 of posts when in fact there were only 10 posts of executive engineer on that day. This was done obviously with the purpose of accommodating him. Third, the promotion was given when respondent number 1 was not even eligible as per rules and he had not put in minimum service of 5 years. Fraud vitiates every action
That
That is the ground of fraud. Yeah.
yes. No.
and cannot be kept under the carpet on the ground that the action challenge was belated.
That is the only exception for challenging the delay aspect.
My lord.
If it is
In
fraud is there, matter is something different.
my lord, in this case, my lord, let me allow me place the information. Their office note says that he was not eligible. He did not secure the qualifying mark 60%, my lord. He
Yes.
secured 55.90% of mark. My lord, not only he declared pass, but also he placed above all meritorious candidates, man, in the seniority list, man. That is my grievance, man.
All right.
Let him declare pass, but he cannot be placed above us, as because arbitrarily we have secured more marks, my lord. Moreover, my lord, if my case will be allowed, no other person except opposite. There is a dispute between myself and opposite partner 6 mile. No other person will be affected if my case will be allowed, my lord. And another judgment.
All right, we'll pass the order.
Let me take another note in consideration.
Please pass on that.
Para 32 of this judgment, my lord. And page 6 of my resolution. Only I that you. Just take out. Para 32.
30.
32. My lord, got it?
Yes.
It is true that mistake was of the department and the respondent was promoted though he was not eligible and qualified. But we cannot countenance the submission of a respondent that the mistake cannot be corrected. Mistakes are mistakes and they can always be corrected by following the process of law. In ICAR versus C.K.Sahoo Hon'Ble, it was held that if erroneous promotion is given by wrongly interpreting the rules, the employer cannot be prevented from applying the rules rightly and in correcting the mistake. It may cause hardship to the employees, but a court of law cannot ignore statutory rules. May I pray, my lord, you will also kindly give a glance page 26 of my report. With respect to this office letter dated so and so.
You see what you have written, that there are some unreserved candidates who have secured less
No,
than
this
so
is
and
their
so
office note, man.
in so and so.
This is the office note of office, man. On my representation, man.
Yes.
From NS 4 to 6, it is clearly evident that irregularities have been done during the selection process made for the post of skill action grade 3 in 2005.
Where are you reading? Page 26. Huh?
Page 26 of my read, sir.
Page 26 is a note.
Note, office note.
Huh?
On my representation mail. That
Yes.
information I got under at the act mail.
Yes.
Line number 3 mail. From note sheet 4 to 6, it is clearly evident that the irregularities have been done during the selection process made for the post of skill action grade 3 in 2005. Now, my lord, the lawsuit can go to the next page.
No, you please carry on. Place that paragraph.
Division has also furnished the evaluation sheet which is placed at flag 65 for perusal. It may be seen that there are some EOR candidates who have secured less than 60% marks and some SC/ST candidates have less than 50 marks have been declared passed. And accordingly, office order number 15 by 25 dated 29 March 2005 was published by Khurda Division. In the said panel, Dilip Kumar Samal was serial number 8, secured less than 60%. My lord, whereas the qualifying mark is 60%, my lord.
Yes, read it out.
Mr. at serial number 4 secured more than 60%. It is learned from office order number so Dilip Kumar Samal has been placed in the higher position, that is serial number 8, in spite of securing less than 60%, whereas Sri S.K. Mr. having secured more than 60% has been placed below Sri Samal at serial number 14. If agreed to, we may return the case file to division with the direction to set the right problem at their end or otherwise. Now, my lord, note number 10, notion number 10, next page. Procedure for filling of the post of skill artisan. Now, take 3 is published by RB number 2290, and for the filling of 25% LDC quota from seniority Khalasi and Khalasi helper is indicated in para 2 of the RB number so and so. As per 2 remaining 2A and 3, the selection is subject to written test and viva, now record of service with 85 and 15 marks respectively. And those who qualify in the written test with 60% mark to be allowed for viva, and those secure 60% against aggregate will be qualified.
Will qualify to be included in the panel. Yes.
However, the panel will be drawn as per seniority. There will be no classification of outstanding.
So they are not totally, that means excluded.
Next parameter.
Yes.
Next of the proceeding drawn and a result published by Khurda may peruse at flag so and so. The panel is drawn as per seniority. However, Sri D.K. Samal Khalasi secure 55.9 marks and Sri S.K. Mr. Khalasi secure 65.55 marks. My submission before my lord is that qualifying mark is 60%. Out of 100, he secured 55.90 marks.
No, there may be some other.
Yes, 55.9.
55 out of 100, he secured 55.90% mark.
Yes.
So he is a failed candidate.
Failed candidate.
Mine.
But his case can also be considered. That just you read it from the top. Even though that was just read few lines below. Few lines above. That those who qualify in the written test with 60% mark to be called for viva bus, and those who secure 60% aggregate shall also be qualify so and so. That means even if he has not secured in that written 60%, but if his aggregate is 60%, he can also be called.
My lord, his total mark is.
अरे आपण खाली से written test टाकू धरले हबनी. Written test रे 60% न रहिले मध्य जदि aggregate रे 60%, aggregate means it may be on some other aspect is to be taken into account. In that, if also it is 60%, then he can also be qualified for so to be included in the panel. So we do not know that why his name has been included and he was selected. If it is only your case that he has secured in the written test 60% mark, even if it is correct. So that does not debar him the authority to include his name in the panel, because once his aggregate comes to 60%, he can be included in the panel.
I may pardon, my lord, I have specifically mentioned the total marks secured by opposite party number 6, my lord, which they have neither denied nor disputed. My lord, he secured 45 out of 85 in the written test. Page 34, my lord, that I have mentioned specifically.
Not to open a case which was already taken place 20 years back, and so many persons might have retired, so many persons
No, my lord,
might
we
have
are all in service. That is a dispute between myself and opposite partner.
All right, all right. All right, we'll pass the order. Next. Next.
My lord, our appearance will noted.
Yes, item
PSJ
number.
along with my.
Please don't sleep. Not a big see.
Item 16.
The input order is annexed 3. The case of the petitioner has been rejected by the Honorable Central Administrative Tribunal. The fact of the case, the mother of the petitioner working in SAIL, Steel Authority of India, while compassion happened. While she was in service, she suffered cancer and subsequently died. The son of the present petitioner's son, is also applied for compassion appointment.
To which rule or circular you are referring?
That lordship can see the page 52. Start from page 52, 53. Lordship. The guideline for dealing with the compassionate case. Running to 50. Start from 52. 52. Start from 52.
Yeah.
How you are eligible?
54. Lordship, page 54. Relevant for page 54. 5.3.1. The medical invalidation case. Compassion employment may be considered depending family members or medical invalidation. The mother of the present petitioner, the medical invalidation. Let's see, the page 67.
କୋଉଟା ଆପଣ ପଢିଲେ ଏଇ ଯୋଉ ପେଜ 54
ମୁଁ ପଢିଲି 54
ହଁ
5.3.1 medical invalidation case. Fourth paragraph.
What is that definition has been given anywhere? What is does it mean?
Medical invalidation of an employee.
Has it been defined that what would be a actual?
The medical invalidation employee, that is annexure 1. Let's see, can turn page 57. That the list of disease have given. That is again page 57. Serial 1. Cancer advance. Bracketed advance.
Okay.
Well, admittedly, my mother was suffered cancer. That is, if let's see, can see the page 67.
That is your ground in the before the
yes,
tribunal. Please show us that relevant. Just don't be fast. Please ask where have you stated that your mother was suffering from cancer and he was coming within that. Yes, where have you stated?
That is admitted case. That is
admitted कर आपण देखो ना दी आपण ओरिजिनल एप्लीकेशन ने कोड से ग्राउंड नहीं चंदी.
The annexure.
Annexure 1 is your original application, right?
The page 17, paragraph 4.2.
4.2. Just come to that.
The mother,
yes.
The mother of the applicant, while was working as a Safai Karmachari in General Administrative Department of Raulkela Steel Plant, was referred to Medical Director Hemlata Hospital, Bhubaneswar on 29/11/2012, where it was diagnosed that mother of the applicant is suffering from carcinoma pancreas in advanced stage.
Okay, let us see that annexure 2. Of your OA.
Annexure
please show that. Annexure 2 को अपन rely करी कहउछन ना.
आगे
Counter affidavit, right? Original.
53 section page 50 guideline for you.
No. जो सी कौन
से जो
Annexure 2 Annexure 2. Please come to Annexure 2 page 32.
मेल
Hmm. 32 रे
मेल
that is a letter of the director to the medical director so and so कौन हला तापरे letters is valid. एटी कौन लिखा है पढ़ो एक नंबर रे.
The Mrs. Sita Vera with advice to obtain performance certain in a include guideline booklet duly filled in and signed by the concerned authority. The above referral hospital are submitted to senior DD path along with the documents in terms of PP circular number so and so 708 dated 12/10/1995. If in the medicine is required to be purchased directly and advised by the doctor of the above normal hospital, you are obtain the signature of the doctor on the essential certificate or reimbursement of the cost of the medicine. The patient is advised to stay nearer to referral hospital so far as possible.
अपन कौन लिखिले paragraph 2 रे अपन का original application है कौन लिखिले paragraph 4.2 रे you have mentioned that the mother of the applicant who was a Safai Karmachari in the General Administrative Department of Raurkela Steel Plant was referred to so and so, where it was diagnosed as mother of the appellant is suffering from so and so in the advanced stage. You are this is referral letter. Referral letter तो किसी नहीं a type of disease रे or which is in the advanced stage. कारण advanced stage नहेले आपण ता देरे include ही परिवे नहीं से जो relief पाइबा पाई.
And that is not admitted, that is not disputed. The question
अरे
is
आपण ଆପଣଙ୍କ ପାଇଁ ହୁଏତ ଆପଣ disputed ନୁହେଁ କହୁଛନ୍ତି. We must be satisfied that you are coming within that particular जोटाको आपण reflect करूଛନ୍ତି जोटाको आपण indicate करूଛନ୍ତି जे एई particular category रे medical invalidation ଆସିले ହିଁ ପୁଅ ପାଇବ.
software if lordship that I have not drafted the lordship the if
You have not drafted.
That is the
ନହେଲେ ଆପଣ ବର୍ତ୍ତମାନ convince କରାନ୍ତୁ ଆମ
if lordship the medical board if lordship the can say the page 68 my lord page 68 for a moment let's
So unless the cancer is at an advanced stage, can you get the relief? Can it be declared that? So that must come within that category, right? So there must be something on record that your mother was suffering from that advanced cancer. So where is that document?
Then a lordship give some other title because on that basis the medical board has declared unfit my lord. That is my
ଦେଖାନ୍ତୁ ଆପଣ ସେଠି medical board ରେ ଲେଖିଦେବ
68 ସେ କଥା କହୁଛି
68
68
କଣ ଦେଖନ୍ତୁ
देखिए the fact representing application number so and so request from medical invalidation the personal policy number so and so the committee considering terms of above referral circular has considered your appropriate request perusal oblique examination of the concerned papers public document has declared you medical invalid for continuing in the service of the company. On that ground the medical board has considered declared unfit medical invalidation.
Then why your application was rejected by the tribunal?
Case my lord. The subsequent lordship on the next page, page 69, that the allegation that I have the subsequent that letter page 68 that the authority has declared on 7/2/2013 medical invalidation. Prior to that, the allegation that I have the mother of the petitioner written that I do not want for medical invalidation. The next page, page 69. 69 also 70. That is the
She did not want.
She did not want.
She did not want.
Then
What is the question?
my submission before Lordship mail, if Lordship can the circular mail, there is no such provision. Once a person has been declared by the medical for invalid mail, they cannot withdraw mail.
Then
Cannot reverse.
So compassionate appointment cannot be there. She may not be declared. How can you claim? Because the person against whom you need to be appointed on compassionate basis, she does not want. Can you force?
Once the person
it is at the option of the person.
Once a person is invalid mail,
just listen to the answer.
The person who is found to have been invalidated, she does not want that any compassionate appointment should be there. How can we insist?
Not compassionate appointment. She doesn't want for invalidation. ଆଜ୍ଞା ସେଟା ତ ଇଏ କୋଉଥିରେ ରୁଲ ତାଙ୍କର ସର୍କୁଲାର ବି ନାହିଁ. So that letter I am disputing.
So that letter is a dispute interest between you and your son, the mother and son. Mother doesn't want that the appointment should be there.
At the stage of advanced stage of cancer mail,
that is the ground.
That is mail the.
Otherwise, how can she should rather support that yes, compassionate appointment should be there because I am invalidated, irrespective of the fact she declares herself or not. But she doesn't want.
And this letter was of the year 2013, and thereafter she must be continuing in service.
Is she continuing thereafter? Or she discharged?
No. Subsequently she died, expired.
She died?
Subsequently she died. She died on 24 April 2013.
So according to the opposite party, the mother applicant did not convey her acceptance with regard to this appointment. She did not accept it.
Just come to paragraph 11 of the impugned order. The operative part. Just reasoning has been given.
That is mail. That is
page 83, paragraph 11.
From it is clear that even the applicant is known that mother had applied for not considering her case being declared as a medical invalid. Therefore, the contention of the applicant that the said letter are false and fabricated doesn't sound right and proper. The respondents had, as per scheme, declared her medically invalid and given her 3 days time to accept the said declaration by the committee. In the meantime, the mother of the applicant, by her letter number so and so, had requested for withdrawing her case consideration by medical invalid.
And to continue her.
The respondent considered her letter treated as the continuing job, and she died while service of the company. There, the process of declaring medical invalidation has become infructuous due to withdrawal of the request of the employees. As on the date of death of mother of the applicant, she was serving employee and not deemed to have been declared medical invalid. Further, as per the scheme, it is for the employee concerned to apply being declared medically invalid along with nominating dependent for compensation appointment. The employees had requested for it, and after approval by the committee and requested for withdrawal of the same, which is also done by the respondents. Under the scheme, there is no provision for the dependent, that is applicant, to apply declaring employee as a medically invalid and for grant of compensation appointment.
So when did she die?
Died the 24th 22nd April 2013. That is also that is, let's see, page 36.
Thereafter, the mother of the applicant died on 22/4/2013.
And that is the unnecessary.
While referring to respondent letter number 7/2/2013, reiterated that her request by letter dated 26/12/11/12 be considered as withdrawn and she may be allowed to continue in service. They submitted that the said request of the deceased employee was considered and she was allowed to continue in employment. Anyway, she died on 22/4/2013.
Well.
But that death is a natural death.
No, due to cancer, not natural.
No, where is that? Where is that?
That is the page 21. Page 21. She expired last line, running page 20, sorry, 36, sorry. Internal 21, running page 36.
Yes.
Last line, my lord. She expired in a hospital on 22nd April 2013 at 2:40 a.m. due to carcinoma pancreas with secondaries.
So after this, again he applied for
No, my lord.
Then?
No, they again, that is, prior to that, my lord, they have applied. I mean, the mother of the petitioner applied, my lord.
Now the cause of action has to be different.
Prior to that,
that remained in dispute because the mother insisted to allow her to continue in service. So she was also allowed in service. So after the death, did he apply?
Yes, that is, she applied, my lord. That is on page 71, my lord.
71.
71. Running page 71.
So what is the ground on which tribunal rejected?
Tribunal rejected the same ground, that ground page 11. That is the
prior
same.
to the death. After the death? That is prior to the death. After the death?
That the tribunal order.
This date which you are referring to, this application at page 71, just see the date in below that application.
So
27/3/2013.
Prior to death of the
So question which is, please try to follow the question. Your mother died in April 2013.
Because your cause of action still subsists after the death also, because the ground of compassionate appointment is one with which your mother was suffering. So we have not applied. This is prior to that.
After your mother died, did you apply because your mother herself withdraw it from? So thereafter, when this application was made for the first time, 2013, it is not that application.
The first time application, my lord, lordship.
That is
The
2013.
67, my lord. While the mother was alive, she has.
That's after the mother was alive, expired, died. When you whether any further application has been made, then how can you? Because prior to the death of the mother, this sort of application could not have been entertained because your mother insists that she should not be declared as medically invalid.
And continue to be in service, and it was also
allowed. It was allowed. So ସେଇ ବେସିସ ରେ ସେତେବେଳେ ଆପଣଙ୍କର କିଛି କଜ ଅଫ ଆକ୍ସନ ନାହିଁ ଯୋଉ ଇଏ ପାଇଁ ଫାଇଲ କରିବା ପାଇଁ। ତାପରେ ମଦରଙ୍କର ଡେଥ ପରେ ଯଦି ଆପଣ ଆପ୍ଲାଏ କରିଥାନ୍ତେ ମ୍ୟାଟର ଉଡ୍ ହାଭ୍ ବିନ୍ ଡିଫରେଣ୍ଟ, ବଟ୍ ଆପଣ ଆପ୍ଲାଏ କରିନାହାନ୍ତି।
Lordship, permit then I'll.
Why to permit? You have a right under the guideline.
They'll reject my application on the ground of limitation.
No, that time reject. What is that?
Lordship can permit me, I can apply.
As such, true. In 2013, the death has occurred. Now it is 2024.
2013, I am before Lordship, my lord. Earlier application, thereafter I will after the cat.
Because of this, you are banking on this particular application, which could not have, the basis is if the basis would have been proper, matter is different. But the basis is that by the time you filed the application, this was the problem. Your mother was a regular. He was so. And is there anything in that compassionate appointment scheme that after this particular period
that is also given?
Where is that?
Within that is page 54,
54.
Within 3 months.
So
page 54, 5.2.2.
That period has long since expired. 54, 5.3.2.
5.2.2.
5.2.2. The request for compassionate appointment should normally reach the competent within 3 months. All right. This writ petition has been filed by the petitioner Sarat Chandra Behra, challenging the order dated 28/7/2023, passed in OA number, passed by the Reliance Central Administrative Tribunal, Cuttack Bench, Cuttack, in OA number 682 of 2019, as well as the later dated 24/6/2014, wherein the application of the petitioner for compassionate appointment has been rejected. Further prayer has been made in this writ petition for a direction to the opposite parties to give the petitioner compassionate appointment. The learned counsel for the petitioner submitted that the mother of the petitioner was working as Safai Karmachari in the General Administrative Department of Rourkela Steel Plant under Steel Authority of India. And while she was under treatment, an application was filed for declaration of medical invalidation. And in that application, it is mentioned for compassionate and for a compassionate appointment to the petitioner, being her son. The committee declared the mother of the petitioner as medically invalid, and the said decision was communicated to the mother of the petitioner by letter dated 8/2/2013. It appears that where is that application filed by your mother?
Mother, page 69.
69. That the mother of the petitioner submitted a representation before the General Manager, Rourkela Steel Plant, Rourkela, for withdrawal of the application for medical invalidation, wherein it was stated that her case should not be considered for medical invalidation and to continue in this service. And accordingly, she was permitted to continue in her service. While the matter stood thus, an application was filed. आपको जो application टा देखे लिखे पे सेटा जोटा आपको पुओ जोटा
Page 71.
page 71. The petitioner filed an application before the General Manager, P&A, Rourkela Steel Plant, Rourkela, for compassionate appointment under medical invalidation ground. And thereafter, when your mother died?
My mother died on 22nd April 2013.
Sure.
That is my Lord Second is page 36. That is.
No, we are asking you, is it sure?
No,
22nd, just
official letter, my lord.
22nd for
2013.
2013. Please come to that page 72. if your mother died in April, how do you can annex that death certificate in March 2013?
That may be. If the lordship, that is right. Perhaps the 5, the 27th
Perhaps,
May.
what perhaps?
Lordship, allow me, lordship, tomorrow I'll take instruction, my lord. Because they have received in 31st May, my lord. If lordship page 71. That
আমি କିଛି ଏଇଟା ଆପଣଙ୍କ ଆପ୍ଲିକେସନ ତ
ଆଜ୍ଞା ଆଜ୍ଞା
ଡେଟ୍ ଆପଣ ମେନସନ କରିଛନ୍ତି ତ
3ଟା 5ଟାକୁ 3 ଭଳିଆ ଦେଖିବାକୁ ତ ମୁଁ ହୁଏତ ପଢିବାଟା ଭୁଲ ହେଇଥାଏ
ଆମେ ତ ଏଠି ବଡ କରି ଦେଖୁଛୁ ସେଇଥିପାଇଁ
ଆଜ୍ଞା
ପୁରା କ୍ଲିୟର ଲେଖା ହେଇଛି 27/3/2013
3ଟା ଟିକେ ଓଭର ରାଇଟିଂ ହେଇଛି ତ 3ଟା ଓଭର ରାଇଟିଂ ହେଇଛି ବଟ୍ ଦ ଆପ୍ଲିକେସନ ଦେ ହାଭ୍ ରିସିଭଡ୍ ଅନ୍ 31st May page 71
ଜାଣିନୁ ଆମେ ଏଟା 27/3 ଲେଖା ହେଇଛି that is why
They received it on 31st May.
31st May, that is page 71.
and your averment is also that you have submitted the application on 27/3/2013.
How can it be?
ଦେଖନ୍ତୁ 27/3/2013. Most peculiarly, in that application, the death certificate of the mother of the petitioner has been attached, even though his mother died on 22/4/2013. The Lenin Tribunal, in the what is the order of the tribunal? In the order dated so and so.
Lordship permitted me, the order it has in 27/5, in order it has been mentioned 27/5. Plus I have no
You have mentioned in your original application that
but
it is
no order, my lord, lordship comes to the page 82, my lord, paragraph 11, that has been mentioned on 27/5/13.
ଆପଣଙ୍କ ରିଟ୍ ପିଟିସନ କୁ ଆସୁନାହାନ୍ତି କଣ ଆପଣ ରିଟ୍ ପିଟିସନ ଦେଖିଲେ କେବେ ଡେଟ୍ ଆପଣ ଦେଇଛନ୍ତି ସେ ଆପ୍ଲିକେସନ ଲେଖୁଛନ୍ତି when you submitted the application.
ମୁଁ ଲେଖିଯିବି paragraph 6 ରେ submitted application 27/5/2013. Paragraph 6 ରେ page 6 ରେ paragraph 4.5. Paragraph 6 of my writ petition.
Or let take down that say submitted the though it is mentioned in the application is dated so and so person. The Lenin Tribunal in the impugned order held as follows, quote paragraph number 11. Since the mother of the petitioner, after being declared, say page number ta kete se jo medically invalid 60 kete kohuଥିଲେ
68.
Okay. After being declared as medically invalid by the committee, on perusal public examination of the connected papers and documents, and conveyed the same to the petitioner's mother for acceptance within 3 days for being discharged from the service of the company. But the mother of the petitioner requested the committee not to consider her case for medical invalidation and prayed for its withdrawal, and also prayed to and also requested her to join her duty, and accordingly she was permitted by the authority. The application which has been filed by the no, if it is not if it is thereafter, then if it is 27/5/2013, then after the death, then how can we get will be we were thinking of that it was a before one, then we are passing the order. But if it is after then, that was considered lekhun, the application was filed, and we find that the Lennon Tribunal has assigned cogent reasons for not allowing for finding no illegality on the part of the respondents in rejecting the claim of the applicant. In view of, after hearing the Lennon counsel for the petitioner and going through the reason assigned by the Lennon Tribunal, we find no infirmity or illegality in the same. Accordingly, the original application stands dismissed and the writ petition stands dismissed. Yes.
Item 17.
My lords. An application for approval of the Khasmal lease land granted in favor of the petitioner, my lord. The Khasmal lease case number 157 of 2014 was initiated, and the land was settled in favor of the petitioner and his co-sharers, my lord. And it was sent to the sub-collector for approval as a statutory mandate. Once the sub-collector returned the file with some queries and it was complied, and I may draw your lordship's attention to page 39.
You have submitted any representation?
The representation was submitted by answer. At last, the representation was submitted.
Where is that?
That is at answer 9.
So, what is the date of the representation?
Representation was of the 16/10/2023.
You have not got any response from the authority?
No response was received. And what I beg to say that the order of the Tahsildar is very specific, and the query made by answer 7 and 8 is unwarranted for any purpose, my lord.
No. There the original lease deed on the basis of the notification was called for. Collector.
Original lead is not necessary, my lord.
Yes. According to you, the notification says about the lease deed or sublease.
Sublease deed. Sublease deed was submitted. Original lease, my lord, that was
So
partner.
let them dispose it of this. In view of that,
the petitioner has challenged the order dated Annexure 7 and 8, na?
7 and 8.
18/5/2023, passed by the Deputy Collector, so also dated 4/9/2023, same Deputy Collector. The Land Council for the petitioner submits that highlighting the illegalities committed by the sub-collector Sadar Katak in the aforesaid two orders dated so and so, so and so. He submitted a representation before the Collector Katak on 16/10/2023. Along with some documents for consideration of his case. However, there is no response from the Collector Kotak, and the representation is still pending. And the Collector Kotak may be directed to dispose of the representation in accordance with law within a specified period. The Land Council for the state has no objection to such submission, considering the submission made by the Land Council for the respective parties. If any such application or representation dated 16/10/2023 as already is pending before the sub-collector, before the collector Katak bracket to opposite party number 2, the same shall be disposed of preferably within a period of 3 months, and the order be communicated to the petitioner from the date of production of the certified copy of the order before the collector. From that period, it will be counted as 3 months. It is made clear that we have not expressed any opinion relating to the merits of the claim which has been made by the petition. Accordingly, the writ petition is disposed of. Yeah. Free copy of the order be handed over to the Land and Council for the state for onward communication to the collector. Yes.
Item number 18.
Lord's compensation has been awarded only dispute matters for apportionment between the co-shareholders.
No, after a direction issued by this court for disposal of the representation,
Matters.
the matter has already been taken and considered by the authority.
Matters.
An order has been passed.
Pass.
So how you differ with that?
Matters. The orders matters. Be equal share of the co-shareholders.
So when there is a factual finding required in the matter, why don't you go to the LA court?
So, that is my prayer. Lara Section 76. Section 76 matters. Any dispute?
Yes.
Just let us.
Any dispute arise to the apportionment of the same or any part.
Just a minute. Please wait. Which section you are referring to?
76 matters.
But for a statutory right, what do you expect a direction from this court? It's a statutory right.
76 says that dispute as to apportionment, right?
Matters.
So when the amount of compensation has been settled, if any dispute arises as to the apportionment of the same and any part thereof, or as to the persons to whom the same or any part thereof is payable, the collector may refer such dispute to the authority.
Matters.
So the authority has been defined. Who is that authority? Authority means that is 3A. Authority means land acquisition, rehabilitation, and so on. So authority established under section so on. So you have to approach the collector. The collector, if he decides, he may refer that to. Why have you come? That is the question which has been asked. Why have you come in a writ petition when the alternative remedy is available to you?
Dispute has arisen Lara land assemblies, redevelopment and redevelopment
The
authority.
property,
Yes, Mr. Tripathi.
yes, sir, the property that compensation amount distributed among the legal householders. And he has not challenged the genealogy
That
also.
is not the, yes, family pedigree has not
Now
been challenged by you.
he is saying that the daughters are not entitled to get.
So that is how the dispute relating to the daughters should not have been given. So it's a dispute relating to the apportionment. That is the.
But he has not challenged the genealogy of that.
In any case,
He has
if
admitted
at all-
the genealogy also. And after 2005, the daughters have also right.
you have no scope in this writ, in fact. Where is the scope in the writ? If at all you had to challenge that aspect without challenging even the family pedigree, you could have gone to that.
He has
as a
admitted
statutory
the
right.
genealogy.
The order which has been passed by the special land acquisition officer. Please come to that operative part of that order, page 23.
It does not require to, that it refuse to refer.
Yes.
Yes.
Why he has refused the order, the reason has been given here. In view of, please read it, that operative portion. In view of the above position. ପଢନ୍ତୁ.
In view,
page 23 operative portion টা পঢ়ନ୍ତୁ. In view of
the above position, it does not require to refer the matter to the appropriate court without any
valid and just reason as majority of the co-sharers
have agreed upon to the apportionment, and the apportionment has been made in proper manner.
made in among the co-sharers as their content.
So how if this is the observation of the special land acquisition officer, so why a writ would be entertained?
What is the illegality?
Only prayer. Daughters are not and same.
No. That is what Mr. Tripathi is saying. You have not challenged that. See, that is not your case. Simply you are asking for apportionment, whereas the family genealogy is not challenged. It is admitted. So how can you say?
During in this that top towards top, it is mentioned that during hearing of the matter, they did not raise any dispute to the genealogy of the deceased recorded tenants, but they simply denied to pay equal shares to the daughters of the deceased. So ଆପଣଙ୍କର ସିଏ ଭଉଣୀ ନା ସେ ଭଉଣୀ ବୋଲି ଆପଣ ଡିସ୍ପ୍ୟୁଟ କରୁନାହାନ୍ତି, ଆପଣ ଖାଲି କହୁଛନ୍ତି ନାଇଁ ତାଙ୍କୁ ଦିଆଯିବନି।
ନା ଦିଆଯିବନି କିନ୍ତୁ ସେମ୍ ସେୟା।
So that is what has been written, that they did not raise any dispute to the genealogy of the deceased recorded and they simply denied to pay equal shares to the daughters of the deceased recorded tenants, whereas both the sons have equal rights over the property of their father. However, they failed to adduce any just reason in support of their stand as to why the daughters should not get their equal shares from the said khata. That was the reason assigned. Take down. This writ petition has been filed by the petitioner so and so for prayer to quash the order dated 26/2024 passed by the Special Land Acquisition Officer, Lawyer Saktel, Irrigation Project Balangir, bracket opposite party number 5, with a further prayer to refer the matter to appropriate forum, sanction the compensation amount of the co-sharers of the petitioner of lost as valuable land, trees, and well for establishment of this one so project. সেটা here after the project খালি করে দাও। From the impugned order dated 26/2024, it appears that the petitioners did not raise any dispute to the genealogy of the deceased recorded tenant, but they simply denied to pay equal shares to the daughters of the deceased recorded tenants, whereas both the sons and daughters have equal rights over the property of their father. And the petitioners also failed to adduce any just reason in support of their stand as to why the daughters should not get their equal shares from the said khata. Accordingly, the Special Land Acquisition Officer is opposite party number 5 has been pleased to hold that there was no necessity for referring the matter to the appropriate court without any valid and just reason, as majority of the co-sharers have agreed upon the apportionment which has been made in proper manner among the co-sharers as per their entitlement. The Land Council for the petitioner has drew the attention of this court to section 78 of so and so Act 2013, which indicates that when the amount of compensation has been settled and if any dispute arises as to the apportionment of the same or any part thereof, or as to the persons to whom the same or any part thereof is payable, the collector may refer such dispute to the authority. Uh, uh, so even this order has been passed, can you not approach the collector?
No matters.
Why no? Since this 76 says that this dispute you can raise before the collector and the collector can refer it the matter to the appropriate authority, then why you say no? Because the authority has already taken a decision. That is the reason why you say so. All right. Since the authority has already taken a decision and there is no illegality or infirmity in the aforesaid decision passed by the opposite party, we are not inclined to entertain this writ petition, which is accordingly dismissed. Yes.
Item number 19.
Please, Your Lordship. The petition's land was acquired for the minor irrigation project in the district of Unlawful. The compensation was not paid. Therefore, I approached the Sonoma Court, and the Sonoma Court has directed
For compliance.
for disposing my representation. Then order was passed by the collector on Annexure 6 at page 26. Losses, I'll come to page the operative portion of the order, page 27, second paragraph.
Yes.
That during the joint inquiry and verification of records, it is found that an area of 2 acre 26 decimals under holding number 25 pertaining to the plot number 4 of Moja Nuaga Isam Taria 2 starts recorded in the name of either Godnai, son of Ramachandra Godnai, past Josa of village Khanja, the legal heir Dharitri Sao, village Khajuria Munda, Davaninandar, post Bausha Pokari, district the daughter of the recorded tenant alleged that the minor irrigation project of Contamina has been constructed on land of her father measuring an area of so and so under holding number so and so has been acquired in the above project, but they have not received any compensation in connection with the acquisition of land. During field verification and verification report, it is found that an area of 2 acre 26 decimal under holding number so and so fully submerged in the minor irrigation project of Contamina. Considering the above discussion and joint verification report, this court directs the Executive Engineer Minor Irrigation Division Decana to take up the matter with the land acquisition officer concerned, and if the compensation in question has not been paid to the recorded tenant, legally a suitable steps will be made for release of the same minor. The said order was not complied with. Then I have filed another writ petition.
Then what happened? This court passed the order?
Then, my lord, now they have sought for the benchmark valuation of the property under annexure 8, my lord. Collect, my lord, after in the...
No, just come to the order which has been passed by the other bench, the division bench on 22/8/2023. Yes. Please come to paragraph 5, the operative portion. Yes.
22/8.
Right,
In
22/8.
view of the such portion, the inspection stand disposal of directing Apportionment 3 to comply with the order dated 29/3/2023 passed by the collector Anuguru, Apportionment 2 in miscase now so and so within a period of 3 months from the date of production of the certified copy.
So what has happened thereafter?
Thereafter, they have sought for the benchmark valuation of the property. You will also kindly see Annex 8. That the interest correspondence was made in between the Canal district and Angul district, and under Annex 11, the order was passed by the superintendent engineer and minor irrigation division.
It's all right. Then what is your grievance now?
No, they are not.
This is under process.
No, they are not paying the compensation.
So finalize helle sina debe
No, they have not. But they said that you lost.
You mean to say that there is delay as per the order of this court? It should have been
you lost kindly see Annex 11, my lord.
No, आपको time limit जो दिया ही थी
now they said that you make a discussion for direct purchase of that land. You'll also kindly come to
No, what is the status now?
Now they have not done anything to give pay the compensation by the collector on well, you'll also kindly see page 36.
We will say that is to be complied with because it may take some little more time.
You'll also kindly see the page 36 while I'm placing that. Sir, inviting kind reference to the subject cited above, it is submitted here with that estimate with the documents
for direct purchase of private land measuring an area of 2 acre 26 decimal is coming under the reservoir of the contemporary MIP as the set plot bearing number so and so is coming under the Angul district. Therefore, you are requested to submit the proposal for direct purchase of above private land through bilateral negotiation in a DCSC before the collector Angul. The above land schedule is coming under the jurisdiction of Angul district. As the area is coming under the Angul district, the collector and DM Dekara has instructed to submit the proposal to the land acquisition officer.
So how you are affected?
But they have not done anything, my
No, no, no. They want the land to be purchased directly.
directly.
You will be paid your
My lord, they have not taken any step till today.
Except the thing that
Whether the
there is some
collector-
delay, except the thing that there is process is going on. So after 9/2/2014, that
2024
or 24, almost 6 months is
They have
going
not
to be
taken
lapsed.
step till today for a direct purchase. Land has been acquired since 1995, my lord. Since 1995.
Mr. Das, please, the status you may obtain that why there is delay because of this order. Because once he has not filed any contempt application, of course, but in case you fail to conclude it within that specified period, you should have also come forward to ask for some more time because of this difficulty. But you have perhaps you have not filed any such application. So, Lekhandu, this writ petition has been filed by the petitioner Dharitri Sahu with a prayer, a direction to the opposite party to pay compensation for acquisition of plot number so and so in so and so. Prayer dekhi likhi. It appears that the petitioner earlier approached this court in WPC number 25619 of 2023, and by order dated, this court disposed of the writ petition with a direction to the opposite party number 3 to comply with the order dated so and so of the collector on go in miscase number so and so within a period of 3 months from the date of production of the certified copy of the order. The learned counsel for the petitioner drawn the attention of this court to the order dated 9/2/2024, later dated so superintending engineer MI division Denkana, addressed to collector and district magistrate on opposite party number so and so, wherein a request has been made so and so the operative portion dekhen. The land council for the petitioners argued that even though a specific time limit has been given in the order dated so and so, but the authorities have not adhered to the same. Let the status of the proceeding, which is going on for payment of compensation, as per the order of this court, be obtained by the Land and Council for the state by the next date. Put up this matter at 2 weeks for us upon you to Ponage 9/2/2024. So list this matter in the week commencing 20th of August 2020. Yes.
Free copy, madam.
Free copy.
Item number 20.
Item 20, if I may, please, Your Lordship. The inaction of the IDCO authorities is under challenge, Your Lordship, wherein they have not acted upon my representation.
Annexure 3.
Annexure 3, Your Lordship. Dated 22/3/2023.
The writ petition has been filed by Swan So with a prayer for a direction to the opposite party number 1 to 3 to take appropriate action as per law in furtherance of the representation by Annexure 3. The Land Council for the petitioner submitted that even though the representation was submitted way back in 22/3/2023 before the CMD IDCO Bhubaneswar. That is opposite party number. Opposite party करना दी रहा हूँ.
ଆଜ୍ଞା
कितना number?
CMD ଅଛନ୍ତି your lordship.
CMD
opposite party number
ଯାହାକୁ representation ଦେଇଛନ୍ତି ତାକୁ opposite party କରିବେନି. अरे
representative capacity ରେ ଖାଲି opposite party number 1 ରେ ଅଛି.
so and so and copy has been forwarded to CGM so and so, but the relating to unlawful construction of 4-storied palatial building on the leased land of the IDCO instead of sawmill so and so, na? And the no communication has been received from the authorities for the you add implead this CMD IDCO Bhubaneswar as the opposite party, permitted to implead this one so as opposite party number. It number
opposite party number 5.
It would be opposite party number 5 है like that. So opposite party number 5 to dispose of the representation within a period of 3 months from the date of production of the certified copy and communicate the order to the petitioner. It is made clear that we have not expressed any opinion on the merits of the. Yes.
Much obliged.
Item number 21.
Melody, in item 21, the appeal committee, Honorable Justice C.R.DASH was a member.
So
the matter possibly has to
release this matter before any other bench in which one of us, Honorable Justice C.R.DASH, is not a member. Yes.
21 and 19, no? Only
21 is mine, my lord.
All right.
In 21, at page 151, your lordship was a member of the appeal.
29. 21 and 29.
Some of it's 29 same.
Yeah.
Okay, it is to go to the some other bench.
Mine.
Item number 22.
22 may please, your lords. My lords, the land of this petitioner, my lords, was purchased, acquired through direct purchase following the procedure of the Land Acquisition Act of the year 2013, my lords. My lords, they have calculated the benchmark following the benchmark valuation and the solar sum only. My lords, thereafter, the petitioner has filed an application before the collector that we have not been paid the proper market value of the land and the matter may be referred to the authority, my lords. Now that has been rejected by the impugned order under Annexure 4, my lords, at page 25.
Come to that impugned order.
My lords. So this is regarding your application under section 64 of the RFCT LAR and R Act 2013, wherein you have requested to either enhance the compensation amount or refer the matter to the competent court of law for apportionment of proper compensation of law. In this regard, the Superintendent Engineer R&B Division Denkanal has submitted the proposal for direct purchase of private land measuring an acre 0.43 Kisam Rasta in Mauja, Korea of plot number 58, Khata number 310 through bilateral negotiation for the Korean Chak to Bhojodeipur Sasan Road via Ronposi ROW. The said plot and the said road has been directly purchased and maintained by R&B Division Denkanal from the recorded tenant, which includes the petitioner along with his mother and brother. Whereas the DSR Denkanal has submitted the benchmark valuation as on 1/4/2023 and reported that the BMV has been approved on 1/4/22 in the DLC on the basis of sale transaction of last 3 years. Whereas the DCSE has approved the price of plot number 58 having Rasta Kisam as per benchmark valuation of rupees 1,35 lakhs per acre along with 100% solatium. Accordingly, as per the guideline enumerated in GO number 4030 R&DM Department 7/2/2014, the calculation of total land compensation as per the Act of 2013 includes the market value and land amounting to rupees 58,05,000 for an area measuring acre 43 and solatium of rupees 58,05,000. The grand total amounting to rupees 1,16,10,000, which was approved by the DCSE on dated 18/6/2022 through bilateral negotiation. And whereas the petitioner was present in the meeting and agreed to sell their land to Superintendent Engineer R&B Division Dhenkanal on the above approved price and also received the compensation. They have also sold their land to Superintendent Engineer Division Dhenkanal on dated 2010-2023 by the RST number so and so. In view of the above, the claim put forth by the petitioner in his petition on dated 4/2023 is not feasible for acceptance as the claim at the compensation amount was approved by the DCSC held on 18/6/22 and the calculation was made on the basis of government guidelines and there is no provision to refer under section 64 of the Act 2013 in case of direct purchase. Hence, the petition is hereby rejected.
So there was a meeting, you agreed with such price, and then the sell deed perhaps was executed, yes, RSD number
Yes,
so
yes,
and
yes,
so.
yes, Your Lordship.
So thereafter you come forward claiming more amount, right?
Lords, as per their guidelines, my lords, the market value has to be calculated as per the section 26 to 31 of the Act 2013, my lords. That is there. I have annexure 6. I have annexed the guidelines, my lords.
You know, you come to that specific provision 64.
64, my lords.
Let us see that. Yes.
64, my lords. Reference to authority. My lords, any person interested who has not accepted the award may, by written application to the collector, require
So
that the
just
matter
keep
be.
in mind
Yes,
who has not accepted the award.
my lords.
Here is a case where you have accepted the award and also the executed the sale deed.
Lords, my claim is that I have accepted. That is, I'm not disputing. I have accepted, lords, not on the market value, my lords.
No,
As per
that is not the mandate.
So
That is not the
can
mandate.
64 be applicable to a case where you have accepted and executed a sale deed? That is our
Well,
basic question to you. Because the provision it says that any person interested who has not accepted the award may by written applications want so then it can be referred by the collector to the
yes, lords.
for determination to the authority. Okay, but once you accept and then also execute
upon.
the that has been acted upon. So in that case, whether 64 would be applicable or not, that is the thing, because that is what the collector has also mentioned that
Yes,
you
yes, yes.
agreed and executed the sale deed. So this that has been approved. So it
That
has
part
been
I'm not disputing, lords. Sale deed was executed. I have accepted.
no,
I have also received the compensation amount. But here, my lords, my case is that the compensation which was, my lords, calculated, that is not as per the guidelines and without following the act. Even though they have to follow the act, my lords, that is there, my lords. They have to follow the while
so the
calculating.
collector has passed the order under section 64 or not?
Yes.
So in what way you say that 64 will be applicable in this particular manner which has been stated? So here in such a situation when you have been after negotiation you agreed, received, executed the sale deed, our question is that how it would be this you can claim more.
The compensation amount is not fair and not in has not been computed as per the law, my lords, as per their guidelines. Therefore, I have filed the application that the matter may be referred to the authority. That your lordship may kindly have a glance to annexure 6 at page 29, my lords.
So that is why we are asking you to find out a decision that where even if you have accepted, still then the the matter can be referred to the authority. We are just hinting you at that, right? The problem is this, that legal hurdle if you cross, then there is no just find out a decision of the you want it during this week or next week?
2 weeks, 2 weeks time.
2 weeks after. All right. The petitioner has challenged the order dated 19/12/2023 under Annexure 4 passed by the Collector and District Magistrate Dhenkanal bracket re opposite party number 2 in an application filed by the petitioner under section 64 of the So Act 2013. In the operative portion, the collector has mentioned that not only the petitioner was present in the meeting and agreed to sell the land to the superintending engineer R&B Division Dhenkanal on the approved price, but also received the compensation amount and thereafter sold the land to the superintending engineer R&B Division Dhenkanal on 20/10/2023 by registered sale deed. The section 64 of So deals with reference to the authority, which inter alia says that any person interested who has not accepted the award may by written application to the collector require that the matter be referred by the collector for the determination of the authority. We put a question to the land council for the petitioner as to whether section 64 of 2013 Act would be applicable to a case where the compensation amount has already been accepted and it has upon negotiation and it has been acted upon and registered sale deed has been executed. The Land and Council for the petitioner seeks 2 weeks time to study the case law on this aspect. Place this matter in the week commencing from such answer. These of the yes.
Item number 23.
Your Lordship. A pension matter, Your Lordship. This is the second read application of the petitioner, Your Lordship. Earlier, the petitioner approached.
Just a minute. Page 18. So, SOP has already been so please see that এটা কেবে ହେଇଛି 25/1/2026 representation ଟା କେବେ ତାପରେ ଅଛି
Have you got the latest status? Sir, after the communication was made to the government for consideration of the representation, what is the status?
I'll have to find out, man.
Okay. এটা ଆଗରୁ ଆସିଥିଲା ତ ଲିଷ୍ଟରେ ଆସିଥିଲା ନା ଫାର୍ଷ୍ଟ ଟାଇମ୍ ଆସୁଛି?
First time.
First time page 39 है ना बेटा अभी
Item 23 में.
23 first name. Look, this writ petition has been filed by petitioner Prakash Kumar Rotho with a prayer for a direction to the opposite party to sanction and release pension and other retirement benefit in favor of the petitioner with effect from 31/3/2013 and to pay the same within a stipulated period. It appears that the petitioner has submitted a representation to the Register Administration of this court on केबे कले representation of date पे under annexure 3 this is dated केबे annexure 3 दा date केते
My lord, 2/8/2023.
2/8/23
My lord.
court file
Postal acknowledgement the page 16.
2/8/2023. It further appears that in persons to the judgment dated 4/1/2024 by the Honorable Supreme Court in WPC number 643 of 2015, All India Judges Association versus Union of India and others. This court has issued standard operating procedure bracket like SOP, wherein a paragraph 3 to put for one of paragraph 3 जो 3 टा कोट कर दिया पेज 18 में स्वांश in view of such SOP issued by this court, the Learned Council for the state wants to obtain the status of the representation. Put up this matter. केबे रखिवा कहंतु?
Only my lord, I am to intimate status now.
Yes.
7 days.
Because of this just SOP ର येटा देखंतु एटा आपनकर डिसीजन रे हबो लेखा आइछि पेज नंबर 18 रे and you are to that expedite the thing. Is a retired person
and it is pending since 10/10/23.
So can come in the week commencing from 12th of August. Okay, this matter.
Item number 24.
But in this case, evidence of the petitioner annexure 3 pending before the opposite party number 2 collector Sundaragar.
Representation
My lord.
For compensation for land acquisition.
Land acquisition.
Since when?
My lord, petitioner the hard letter stands in the name of
केबेठु पड़ी अछि मो?
My lord, that is a 28/2/2022.
अच्छा. Or the Learned Council for the petition, Learned Council for the state. The petitioners Brindavan Barla alias Brindavan Oram and Indramani Barla have filed this writ petition for a direction to the opposite party number 2, Collector Sundargarh, to settle the compensation towards acquisition of land of the petitioner by disposing of the representation dated 28/2/2022. The Learned Council for the petitioner submitted that the representation on annexure 3 is pending with the opposite party number 2 since such and such is and no communication has been received from the concerned authority and direction may be issued to the authority to dispose. Learned Council for the state has no objection to such prayer in view of the limited nature of grievance of the petitioner. If annexure 3 and the representation dated sworn so is still pending with the opposite party number 2, the same shall be disposed of within a period of 3 months from the date of production of the certified copy and order be communicated to the petitioner. We have expressed no opinion of the merit.
Item number 25.
45, my lord, on behalf of Mr. Sarada Prasad Das, kindly pass out for the day, madam.
Then it will be taken up tomorrow, okay? This and list is.
Item number 26.
26 on behalf of Mr. Barik, I am permitted to withdraw if the order challenge the applicable order may with the liberty to.
The memo has been filed on behalf of Barik sign by the current counsel for the petitioner for withdrawal of the writ petition. The memo is taken on record and the writ petition is disposed of as withdrawn. Yes.
Item 27.
May I please ask? Here, my lord, I'm challenging the order.
Please use the mic properly.
Here, my lord, I'm challenging the order passed by the assistant settlement officer as well as the order passed by the settlement officer. The fact of case is that the petitioner's vendor got the suit land on the basis of lease. After getting the suit land on the basis of lease, he sold out the said suit land in favor of the petitioner, my lord. In the year, my lord, sorry, my lord, the lease was granted in the year 2002, my lord. Thereafter, he sold.
In whose favor lease was granted?
The petitioner's vendor's vendor, my lord.
Okay.
Thereafter, the petitioner's vendor sold out the suit land in favor of the petitioner in the year 88, my lord. The settlement, after getting the suit land, after purchasing the suit land, the petitioner converted from agricultural land to homestead land. Thereafter, the settlement operation came into force. In settlement operation, one objection case was initiated by the settlement officers in suo motu. In the said objection case, the settlement officer has stated that the lease granted by the government in favor of the petitioner's vendor's vendor is illegal, my lord. So he rejected that objection case, my lord. Against that, the petitioner preferred an appeal before the settlement officer. The settlement officer, without issuing any notice, he dismissed the appeal on the ground that he was absent at the time of call, my lord.
Which is that order?
My lord, that is Annexure 8, sorry, my lord, 7, running page 28, my lord.
28.
Annexure 7, page 28.
Okay, this case was filed when? This
15, my lord.
2015.
My lord.
So 2015 ରୁ ଆପଣ 2022 ପର୍ଯ୍ୟନ୍ତ କଣ କରୁଥିଲେ?
My lord, if your lordships kindly see the page 28 last paragraph, my lord. Sorry, my lord, last
2022 ରେ 12/10/2022 ରେ notice issue ହେଲା, right?
My lord.
And the date was fixed to 21/10/2022. 21/10/2022 ରେ notice duly served ହେଲା. SR back, appellant is absent. ସେଦିନ ମଧ୍ୟ ଆପଣ absent ଥିଲେ.
Well, that is my objection, my lord. No notice was issued to the petitioner.
No notice was issued
no notice to the petitioner, my lord. Though they have mentioned the notice was duly served, but no notice was issued.
You are for the appellant or what?
My lord, appellant.
So, appellant who can notice hobo?
Because, my lord, if your lordships kindly see the page 28, the order dated 16/8/2016, my lord.
Yes.
2016 case, last case. Thereafter, no date was fixed by the settlement officer, my lord. In the year 2022, the next page, my lord, 29, my lord. After 6 years, my lord, without giving any notice, then the case was remanded to the SAO, settlement officer.
Okay.
Initially, it was filed before the additional sub-collector Bhubaneswar.
Acha, or receive the appeal case from Acha.
My lord.
Issue notice to the parties. Acha, parties means including you.
My lord.
So, and the next order indicates that the notice was duly served.
My lord.
So,
SR
that
back
means SR back. So, date must have been fixed to 2010-2022.
My lord, no notice was issued. That is my objection.
How do you say so? There must be on record जो नोटिस गुड़ाक जाइथिबो आपनकर एंडोर्समेंट सहित बैक करथिबो ना ताको देखि लिखिथिबे नोटिस ड्यूली सर्वड बोली.
My lord, though I have applied, my lord, they give only the certified copy. They did not supplied any.
In favor of the court, how can we say?
कोर्ट जेतेबेले लेखुचंती आपनको नोटिस पठाला नोटिस टा ड्यूली सर्वड बोली आपण मस्ट बी इट इज बैक्ड बाय सम डॉक्यूमेंट्स जोथरे कि देखुथिबो जे आपण नोटिस जाईची एई एड्रेस रे जाईची आपण रिसीव करिसंती तेनु
That is on the
appeal case is initiated
presumption is
based on
that-
so and so submitted
No,
by
did you
the
challenge it before that authority?
My lord, no, I have not. Lord, because they have no power. Because they have no power, my lord. Because
settlement officer कटंकर order against आउ किछि provision नहीं
no, my lord.
challenge करिवाकू
Challenge
except the writ petition.
My lord, 15B, my lord.
Uh-huh.
15B before the commissioner.
Yes, 15B is there.
My lord.
So
Under the survey
provision
settlement.
which is that
My lord, 15B of Odisha Survey Settlement Act.
दियंतु Survey Settlement Act.
Similar case also decided by this.
No, because you are challenging a particular aspect. Even though the order mentions that notice has been duly served and SR back and attached to the case record. You see, they're very clear. But you say that in spite of such noting, in fact, you have not received any notice. So you are virtually challenging that recording which has been made in the operative part of the order, right? So for that, you are not bringing before us any material, right? So if you would have applied सेई जो जिनस गुड़ाक तांको पाखु बैक करछि नोटिस जोड़ा ड्यूली सर्व हेछि से गुड़ाक आनिकिनी सर्टिफाइड कॉपी हम पाखु प्रोड्यूस करथांदे एवं देखै थांदे आज्ञा देखंतु सर्विस मो ऊपर हेनी ओडा का ऊपर कोन सर्विस कराइछि लेखा हेछि नोटिस ड्यूली सर्व मैटर इज डिफरेंट आपण ताकु करना दिए हर्डल नंबर 1 हर्डल नंबर 2 is that and another forum is available for challenging the order. So why you entertain the writ petition?
My humble submission before lordships. If the ROR is corrected, then 15B is maintainable. So
you just said that a challenge or we put a pertinent question to you that whether against the order of the settlement officer is there any provision under that particular
That is incidental. This is incidental, no?
So whether any order passed by the settlement officer is to be challenged or a particular order can be challenged, other order is be challenged in the writ petition.
No.
Then, so if it is any order passed by this, then you can raise that point before that court. Have you brought that book with you?
My lord, I have come with the OGLS, my lord, not.
Most peculiar, you are coming to argue a matter and you have having no.
Sorry.
So, ayo.
Nice. Can I prefer tomorrow, my lord? Obliged.
Item number 28.
My lord, illegal document of the other of the present petitioner has been reflected in the remark column against the Hall Place Port since 1986. As 13 of the servant settlement rule, the grievance of the petitioner may be looked into to take a decision following provisions contained.
You have submitted a representation via Annexure 2.
Submitted, my lord.
Before whom?
Before the Tahsildar, my lord. Mahakarpa.
Where is that representation?
on page 10.
Page 10 it is এটা তো ଗୋଟେ ହଁ ହଁ ଏଟା ପୁରା ହେଇଛି 12/4/2024 ରେ ଡିଭିଜନ ବେଞ୍ଚ ପାସ୍ କରିଛନ୍ତି ଅର୍ଡର considering the contention raised by this one, so this court direct the Tahsildar to consider and pass order within a period of 3 months. So 12/4/2024 ରେ order pass ହେଲା from the date of production of the order 3 ମାସ ଭିତରେ dispose of କରିବା ପାଇଁ.
One similar order has been annexed here.
Was a similar order.
Similar.
Oh, I see.
Oh, it is not for him.
Acha.
Representation.
It's all right. Like it on. The so-and-so has filed this application with a further prayer. Okay. And the representation is dated so-and-so. It is to be disposed of from the 3 months before. All right.
Obliged.
Item number 30.
My pleasure. In this case, the petitioner's husband was allotted a piece of land measuring 1 acre, 500 decimal mile. And in the year 1980,
What is your prayer to dispose of the remanded consolidation?
that commission before the paragraph 17 your lordship can come.
No, do you mean to say that 2003 revision is pending?
No, 3 times it was remanded. Reversing
ଆପଣଙ୍କ ପ୍ରେୟାର କୁ ଆସନ୍ତୁ ଆପଣଙ୍କ ପ୍ରେୟାର ହଉଛି to dispose of remanded consolidation revision case number 61 of 2003 expeditiously.
Yes,
that is your prayer.
Yes.
So 2003 ରୁ ବର୍ତ୍ତମାନ ପେଣ୍ଡିଂ ଅଛି.
ପେଣ୍ଡିଂ ଥରେ ଅର୍ଡର ହେଇଥିଲା ପିଟିସନର ଫେଭରରେ.
ଆଚ୍ଛା.
ଗଭର୍ଣ୍ଣମେଣ୍ଟ ଆସିଲେ ହାଇକୋର୍ଟ. This honorable high court also set aside and remand.
Last time କେବେ ରିମାଣ୍ଡ ହେଇକିନି ଗଲା?
ତାପରେ once again the commissioner exercising the power under OGLS Act, which is not at all applicable, he cancelled the same. Thereafter, the petitioner came to this honorable high court, and this honorable high court under annexure 11 remanded the case with a direction for expedite hearing.
Okay.
But in the meantime, what happened, my lord?
Just a minute.
After 20...
Please wait. Come to page 61, the order of this court, which you are relying upon.
Yes, ma'am.
That was the last order passed by this court.
Yes.
So please come to that order. The consolidation revision case is restored to the commissioner for hearing and consideration appraised. Yes. It is expected that the case shall be dealt expeditiously. So this is the order dated 29/3/2023.
Yes, madam.
So in spite of such order, you mean to say that
thereafter what happened? The commissioner called for the record and the inquiry report from the Tahsildar as well as the sub-collector from the...
Yeah.
Now, the Tahsildar already given the report after making inquiry through the RI. But while the case was posted on 20/4/2024, the commissioner retired. No commissioner has yet been joined. In the meantime, what happened, my lord? OP number 6 and 7, the BDA, the enforcement officer, BDA and municipality, they are threatening the petitioner will demolish the matter and will evict you. Because
your prayer is very limited. We cannot go beyond that. So, Mr.
prayer is also there.
Counsel, you please take instruction. What is the stage of this and why it is being delayed, as he said. Okay. So it can be taken off a week after you just.
Another case is posted to 7/8.
এটা কাহা পাখরে কাহাকু রেফার ହେଇଥିଲା ম্যাটার টাকু
Consolidation.
এটা court number.
No. It has been remanded to commissioner.
Consolidation.
So
OP number 3.
Lekondu. The writ petition has been filed with prayer by so-and-so with a prayer for disposal of the remanded consolidation revision case number 61 of 2003 expeditiously. It appears that when the petitioner approached this court in WPC number so-and-so as per order dated 29/3/2023, this court not only restored the consolidation revision to the commissioner for hearing and consideration afresh, but also expected that the case will be dealt with expeditiously. The Land Council for the petitioner submits that there is delay in disposal of the aforesaid revision case. Let the Land and Council for the state obtain instruction about the status of the revision case and the time period within which such a revision petition is likely to be disposed of by the concerned authority. Put up this matter in the week commencing from 12th August 2024. Yes.
Till then status quo. Each and every day, because you are
We do not know anything about the status.
it is a converted land. PDA plan approval for it is a ghar bhi karchi. In the meantime, what happened is that 321 plot, जोटा कि by plot ହେଇକିରି ନା ହେଇଥିଲା.
See, we do not know there are other parties are there.
Interim.
No. What would be the status of
Not
the
to take
case?
any courtship action
Sorry.
within this period,
Yes,
madam.
next.
Item 31.
7, 8, another case is there.
Item number 31.
Item 31 and 34, 35.
Yeah.
All are similar, just here only representation is pending before collector. That because they are not granting the benefits under the displaced persons and project affected persons. And all the three applications.
Pending achi.
Lordship, in first case, Lordship, kindly say my representation pending since 10/7/2023 in first
Before whom?
before collector Kalahandi Lordship.
All right. The petitioner, petitioners like them, have filed this writ petition with a prayer for a direction to the opposite parties, more particularly the opposite party number 3 and 5. That is Collector and District Magistrate Kalahandi and Land Acquisition Officer and so on. For consideration of the grievances of the petitioner by in extending the benefits under the scope of either displaced person or project affected person by releasing appropriate compensation amount forthwith. The Mr. Dalai Lama Council appearing for the petitioner submitted that highlighting the grievances, the petitioners have submitted a representation before the opposite party number 3. Five अच्छी किधर है? यार कॉपी तो ताको दिया ही नहीं कोड लिखा ही नहीं खाली लिखा है जी माननीय जिलापाल कलाहांडी लिखा है जी और तले तो लिखा ही नहीं यार कोई एक किता कॉपी ना देखा अच्छी गया ऑलराइट ऑपोजिट पार्टी नंबर 3 and 5 on 10/7/2023 but they have not received any communication from the concerned authority relating to the status of the representation and therefore it may be directed to dispose of within a specified period. Land Council for the state has no objection to such prayer, considering the submission made by the Land Council for the respective party. If the application under Annexure 3 series are pending before the opposite party number so and so, the same shall be disposed of within a period of 3 months from the date of production of the certified copy of the order, and the orders shall be communicated to the petitioner. And it is made clear that we have not expressed any opinion on the merits of the so yes. I would have put
34 Lordship 16/5/2023 same annexures.
तार date खाली
16/5/2023
अलगा वो item number 33
34 Lordship
34 3 months disposal. I would have put
35 Lordship 35 rows 27/12/2023
date देखी थे representation date देखी
29/12/2023
all right.
Lordship grateful Lordship.
Item number 32.
Mr. Mishra.
May I please, Your Lordship? My Lord, the initiation and continuance of a departmental proceeding against the petitioner is under challenge in this writ petition. But the initiation is challenged on the ground that the very initiation is contrary to the guideline that has been issued and circulated, my Lord, under Annex 3 at page 107. May I draw your lordship's kind attention to page 107 annex 3.
So you have submitted your written statement also, written statement of defense.
I have submitted written statement of defense. I have also taken a stand that this proceeding has been initiated on the basis of an unverified resolution which has not been supported by sworn affidavit as has been circulated to all the register
No,
general.
what happened thereafter, Mr.
Thereafter, your lordship will see under
This,
annex.
this objection is stated to have been submitted on what date you submitted?
Written statement of defense.
Written statement is on dated 3/1/2022, right?
Right.
So, what is the stage now?
Now the proceeding is going on. Now under Annexure 4 series, I have annexed some of the petitions and the order passed therein. Your lordship will find even I am not given a chance to defend. If I file a petition to summon the witnesses, that is being rejected. If I filed a petition to cross-examine the witness that is produced on behalf of the authority, that is being rejected. But your lordship will see the total proceeding is proceeding almost fixing the date very short dates without providing any opportunity to me. But that is how the proceeding is continuing, my lord. Your lordship annexure 4 series, if your lordship will kindly peruse from page 108 onwards, and I can point out to your lordship few pages just to fortify my submission, my lord. Your lordship,
District judge must be the inquiring officer, na?
My lord, there is no dispute about that. But your lordship sees, I have requested page 114. I have requested for copy of orders that has been passed, that is not being given. Then I have requested to cross-examine witness, that is not being done.
Let it be over. You are what is the stage now? Have you adduced your evidence from your side?
But evidence from my side has not come in.
So from their side, your cross-examination is over. All the witnesses have been given.
In fact, in some of the cases, it has been refused.
Then
that is what is happening. But will your lordship
at this stage, we will interfere with the disciplinary proceeding.
Only one ground your lordship will see. I am concerned so far these deviations in the course of proceeding, my lord, can also be a ground if at all there is a punishment against me, my lord, in appeal.
But that stage has not reached. That
not obliged, my lord. I have nothing to dispute about that. But may I just, with your lordship's kind permission, draw your lordship's attention to
and it is not that it is inordinate delayed. It is just a proceeding of the year 2022, and you have submitted your statement, I think, in that 2022, and witnesses are being examined. You have also annexed the copies of the these. You just come to one witness. Let us see page number 50.
No, my lord, that is with regard to the, my lord, the inquiry. These are the witnesses who were produced, my lord, in support of this initial, my lord,
so now after this, how many witnesses have been examined?
My lord, your lordship may pardon me that exact number. My lord, your lordship,
and the day it is the witnesses are examined, you must be given the opportunity to cross-examine also the witnesses.
At times not.
At times not. Then very that document that at times not you are.
Your lordship will see it has been rejected also. Now your lordship may kindly come to page 151.
Suppose it is offered and you will not avail that opportunity.
But that case,
you will make that the district judge has not provided you opportunity.
But if
you are a judicial officer and nobody would not give you the opportunity of cross-examining the witnesses. So that kind of allegation can.
It's not a case of allegation. I am just.
Then you are a senior civil judge. The proceeding is before the London district judge, and witnesses are examined, and you say that the senior civil judge is not getting any opportunity to cross-examine the witness, and this is and most of the why will at this stage interfere with a disciplinary proceeding?
I'm only
very serious allegation against you, Mr.
that allegation also, your lordship will see there is absolutely no substance to it.
As many as how many charges are there? 9 charges are there.
Your lordship may see the charges.
No, we are not here to examine those charges.
But I was just
No, we are not looking at those charges at this stage and to give any finding also. So, authority is in session over the matter, and you are provided why we'll quash the disciplinary proceeding at this stage. Your prayer is to quash the same. Why it will be quashed? What is the reason?
That's the reason.
At this stage,
The reason I beg to point. May I just point out one thing, my lord, for your lordship's consideration, page 107 only. Your lordship may kindly turn to page 107.
No, please show, have you got any decision to the effect that a disciplinary proceeding which is continuing and just for 1.5 years it is there, and when there is nothing, why it is to be quashed, on what ground?
My lord, I'll give that citation before your lordship being physically present tomorrow. I'll just point out one thing. Recently, Honorable Appeals Court in a matter from Orissa quashed it on the ground that the proceeding was initiated 4 years after the purpose for which the proceeding was initiated on the eve of retirement, not on the ground of delay. I'm conscious, my lord, your lordship is hinting at if there is delay, it can be quashed.
Your petitioner has retired from service.
No.
Then?
No, here I am pointing out what? The defect in proceeding. The defect is at page 107. Defect is at page 107, my lord. That's what I am pointing out to the lordship.
You see, now the witnesses are not over. You may also adduce, so we can not even target that within this particular period.
I am not saying for a target.
So,
I am saying that the initiation was on the basis of an unverified resolution to the land district judge, which your lordship will see page 107. It is contrary to that. That much I beg to point out to your lordship. May I place 107, my And this 107, I beg to submit that the very initiation is defective. And the Honorable Appeals Court there also dealt with an issue whether the initiation is defective or not and quashed it. I am not on the question of delay or those 4 years before. I am only on the question there was a defect that there can be no proceeding if the allegation pertains to a period which is beyond 4 years. So here it is a case where there has been a resolution saying that there cannot be any.
Just a second.
all right, you file your citations tomorrow. We'll see that.
Madam. Let it be in the list, my lord. This is a weekly list, my lord. Let it be.
Weekly, it is there. We'll call tomorrow.
Obliged.
All right. Rest of the matter will be taken up from the list report.
May pardon, my lord. May pardon. The item number 36, it relates to the Odisha Judicial Service preliminary examination, lordship. The questions have been set wrong. They are going to declare the result in any moment. It's a lordship. Yes, we had participated, lordship. I pray lordship may take it.
Tomorrow.
My lord, mentioning on matter IA number 2531 of 23, not listed until now.
Yes.
IA number 25 of 23. IA has been filed in 16/10/2023, not listed till now.
It's for bail.
Yes, sir.
Division bench matter. What is the period of custody?
Custody since 2012 he has been custody.
12. All right. That period is there 7 years more than you.
At item number 3, that sub items of criminal appeal 693. On the last occasion, your lordship directed to me to file the list of dates along with the citations. File together.
Have you served a copy?
Yes, Lord, yes, just.
So we'll close the argument.
Yes, my list of dates along with your paragraphs and everything.
Item number 3.
Sub
Item
yes,
3.
yes.
Mr. Sarangi is there.
Sub item that
Mr. Sarangi is virtually present.
He's there. Mr. Sarangi.
Yes, my lord.
So Mr. Das has filed the written note of submission and the date chart or memo of citation.
Yes,
so his part is over, and so anything you want to say, or we'll close the.
If your lordship wants only that sentencing part, I have not answered. What your lordship has seen, it's no premeditation and his background.
Mr.
So no repetition, my lordship. It will amount to repeating things.
Mr. Sarangi, if you want to address us on the question of sentence, there is no problem. You can do it, but let us finish this orders matter. We can take up.
That will be repetition again, my lords. Not required. Your lordship has
up
done
to
it in detail.
It is up to you, Mr. Sarangi. If you want to address us, we are ready.
Because your lordship asked me, I have nothing more to say in the matter.
At this moment, we cannot hear because we'll take up the orders matter.
I know, my lords. Not required, my lords. Lordship may close it.
Okay.
All the materials are before.
Egote ଦେଇଛନ୍ତି ତ? Right, item number 3 na eta CRL number 693 of 2024. Mr. P.K. Das, Land Counsel, appearing for the appellant, filed the list of dates, written note of submission, and list of citations, which is taken on record. Copy has been served on Mr. Janmejay Katkia, Learning Additional Government Advocate. The Land Counsel for the appellant. So also the Lane Amicus Curie in JCRL number so and so and DS number so and so. So also the Mr. Land Additional Government Advocates submits that they have nothing further to argue either on merit or on the question of sentence. Accordingly, this is taken on record. Hearing is closed. Judgment is reserved.
My lord, that the last part of that judgment belonged in 2024, lord.
Yeah.
2nd May 2024, lord. Delivered by Honorable Apex Court, lord. That judgment not with me, but net already available, lord.
Okay.
Paragraph 14 is the most important. Under section 34.
Let's see that. Yes.
Weekly list for orders, item number 7.
Custody certificate.
Yeah.
Last occasion, your lordship directed to produce the custody certificate, your lordship.
Mr. Tripathi,
Yes, my lord.
we also wanted to know from you that whether during the interim bail period,
Yes, my lord.
the petitioner has misutilized his liberty in any manner that is to be obtained through the IIC of the concerned police station. That order was also passed on
Yes.
15th.
Yes, my lord.
So what is your instruction on that?
Instruction not received, my lord.
So why are you obtaining it in a piecemeal manner? So that he was granted interim bail twice. Once on 31/7/2013, on the other occasion on 4/2/2020.
Let it come on Thursday, my lord. I will.
No, this is there in the weekly list.
Yes,
So
yes. That
we can take up this matter on Thursday. There is no এটা Thursday রে রাখিবে এটাও রাখিতাম হলো
Item 8.
My lord, I'm seeking a passover on behalf of the conductor.
Item 9.
My pleasure also. In this case, the appellant was convicted under section 302 of Indian Penal Code, my lord.
Please use the mic properly. You are not audible. This is JCRLA 76 of 2014. And your earlier bail application was rejected or it is for the first time?
First time. I don't know exactly whether it was
Just let us see that, then verify it. Order admit law, then okay. You have produced the custody certificate, Land and Council for the state, and written instruction about the criminal antecedent. Custody certificate कौन देखूची? What is the detention period, Mr. Tripathi?
Yes, my lord. 11 years, 2 months, 13 days.
11 years?
Yes, my lord.
2 months, okay. And any criminal antecedent?
That has not come.
So, okay, what is this case, Mr. Das?
My lord, the petitioner has not involved in this case, my lord. Only the judgment has been passed and he was awarded sentence of the life only on the basis of the circumstantial evidence, my lord. There is no eyewitnesses there, my lord. Not a single witness has supported the prosecution case in this case, my lord. All are the hard witnesses, no one is supported the prosecution case.
No. If it is a case based on circumstantial evidence,
yes, ma'am.
Then what are the circumstances against you?
That has been mentioned by the Lord and Trial Court.
Yes.
Is the last togetherness. And
Last
together they are residing last together. After last in theory, after compromising with the deceased and the appellant.
So how you are related to the
husband and wife?
Oh, husband and wife. You are the husband.
Yes, ma'am.
So what is the name of your wife?
Sabita Sahoo.
Sabita Sahoo. So there was some disturbance. You are staying separately.
My lord.
Then you started living together. And then this occurrence took place.
After compromise, they started living together just prior to 1 or 2 days, my lord.
Then where from the dead body was recovered?
In front of the appellant's house.
Okay. So what is the cause of death?
Due to coma.
Acha. Oh.
Due to coma, the result of injuries.
Okay, lacerated wound on the head, forehead, temporal region, mustard area, so parietal area. Acha. So it is Charita blow Mundukochi, comminuted fracture leading to so and so. Death was due to coma as a result of head injury. So, what is your explanation? What is your accused statement? How your wife died when she was living in your company?
So, as per the statement of the some witnesses, they have stated the deceased always living to his house without the information of his husband, I mean appellant, my lord. And the deceased as working as Asa Karmi.
ମୋ ସ୍ତ୍ରୀ କିପରି ମଲା ମୁଁ ଜାଣିନି, ମୋତେ ସେଠାକୁ ଡାକିଲେ ମୁଁ ସେ ବିଷୟରେ କିଛି କହିପାରିବି ନାହିଁ। ଆପଣଙ୍କ ସ୍ତ୍ରୀକୁ ଆପଣ ପାଖରେ ରହୁଥିଲା, ତାର ହୋମିସାଇଡାଲ ଡେଥ୍ ହେଲା, ଏତେ ଗୁଡାକ ଇଞ୍ଜୁରି ତା ମୁଣ୍ଡରେ ହେଲା, ଆପଣଙ୍କୁ ଆକ୍ୟୁଜ ଷ୍ଟେଟମେଣ୍ଟରେ ପ୍ରଶ୍ନ ପଚରାଗଲା, ଆପଣ କହିଲେ କିପରି ମଲା ମୁଁ ଜାଣିନି। So what is the stage now? Paper book has not been prepared. Are the learned counsel for the petitioner, learned counsel for the state? Learned counsel for the state has produced the custody certificate obtained from Senior Superintendent Circle Jail, Berhampur, which indicates that the appellant is in judicial custody for more than 11 years. Though the land counsel for the state was asked to obtain instruction regarding criminal antecedent, if any, against the petitioner, as per orders dated 9/7/2024 as well as 23/7/2024. It is submitted by the land counsel for the state that he has not obtained any such instruction, though the same has been sought for. Stop. Land counsel for the petitioner submits that the case is based on circumstantial evidence and the petitioner is the husband of the deceased, S.K.Sahoo, and the dead body of the deceased was found in front of the house of the petitioner. And since paper book has not been prepared, there is no chance of early hearing. And balance of convenience is in his favor. Therefore, the bail application may be favorably considered. Stop. Learned counsel for the state, on the other hand, oppose the prayer for bail and place the impugned judgment. So also the postmortem report finding, from which it reveals that the deceased has sustained number of lacerated wounds on the vital part of the body like head, and the cause of death has been opined to be due to coma as a result of head injury. The land counsel further argued that there was dissension between the appellant and the deceased, for which the two were remaining separately, and 2 days prior to the occurrence, the deceased came to reside with the appellant. And in the accused statement, no explanation has been offered by the petitioner as to how the deceased died. A homicidal death. Stop. Considering the submission made by the learned counsel for the respective parties, the nature and gravity of the accusation, while not inclining to release the petitioner on bail on merit but taking into account period of detention in judicial custody, and since the petitioner has already been released twice on interim bail, and the learned counsel for the state has failed to bring anything on record to show that the petitioner has misutilized his liberty. এদের ইন্টারিম বেলে যাইছিল না নাই না সে আরো কেসটা যাইছিল না ছাড় দিন and the Land and Council for the state has failed to produce anything regarding the criminal antecedent, keeping in view the principle laid down in the case of Leti versus State. 3 months interim bail is granted. A report to be called for from the concerned IAC about the conduct, and date is to be posted after 3 months. Yes.
Pardon, my lord. Item 8, my lord. I was on my legs in another court. I humbly pray. Item 8, my lord. I was on another court.
You want to argue the matter?
Item 8, 9th, 8.
It's all right. Argue.
I'm just seeking for the item section 389 application for bail. Petition appellant is in custody since 2008, 1/3/2008. Convicted under section 302, 376 2F.
Deposition copy not supplied.
16 years. Interim bail केवे बाहर नांति केवे.
So it is coming for the first time after admission.
My lord.
You are in custody for 16 years.
16 years. 1/3/2008.
Okay. Mr. Tripathi,
Yes,
you obtain the custody certificate, and if you want to go through the deposition, give your pen drive, it will be given to you. The Land and Council for the appellant submits that the appellant is in judicial custody for about 16 years. Let the Land Council for the state obtain the custody certificate through the concerned jail superintendent. And Council for the state further submits that he is not having the deposition copy. Let the registry supply him the deposition copy in his pen drive. Put up this matter in the week commencing from 12th of August 2024.
So which jail?
Huh?
Which jail?
Who jail रहेगा? କରୁଣା ଦେହେରା वकालतनामा ଯେତେବେଳେ ସାଇନ୍ କରିଥିଲେ 2014 ସେତେବେଳେ ଡିଷ୍ଟ୍ରିକ୍ଟ ଜେଲ ବାଲେଶ୍ୱର ଥିଲେ ଆ ଭିତରେ କୁଆଡେ କଣ ଥିବେଣି ଦେଖିବେ ଆପଣ ତାଙ୍କୁ ସେମାନେ ପଚାରିଲେ କହିଦେବେ ସେ yes
Item 10.
Great.
My lord, in this case, your lordship has directed to file comprehensive affidavit. For appellant number 1, affidavit was filed. Today I am filing for appellant number 2 and 3, my lord. And my learned senior has filed for appellant number 4.
Copy.
Yes, what do you want now?
My lord, I am moving for bail, my lord.
Criminal Appeal 355. There are two interim applications. One is IN number 2284 of 23. This is for 1, 2, and 3. And 2462, it is for appellant number 4.
My lord.
So, Mr. Devasis Panda has already filed the comprehensive affidavit for appellant number 4. So you are filing today for 1, 2, and 3.
1 has already been filed, my lord.
Okay, 2 and 3 you are
2
filing.
and 3.
Your lordship, on behalf of Mr. Jafrullah, please pass over the matter.
For 1, my lord, state has given 1 antecedent. It has been mistaken right in 2023, but this is this case, my lord, 2013.
This case.
This particular case.
Yes. And another case was there that affidavit has been furnished. And for appellant number 2, first case is this case. Other 4 cases antecedents, my lord, affidavit has been given.
What is your period of detention of these petitioners?
11 years.
Okay.
2013 was the custodial.
Period of detention is probably the same for each.
Okay. It is for 13 years.
13. 11 years. 2013 date of custody. A year of custody.
Earlier bail application was rejected or you are granted interim bail?
Rejected. I think appellant number 4 has granted interim bail.
He was only allowed to come to my house one day in custody to attend the funeral.
Funeral ceremony. What is the prosecution case?
Prosecution case will not say that in the morning hours, the deceased.
So it's a cutter case.
Yes, Segwajar case.
Achha.
He was fired at and he escaped. He came in his scooter to his house and was taken for treatment. And at the hospital, he succumbed to his injuries. He was first taken to SCB, from there to this private hospital here in CDA Millers. And there he succumbed to his death, Millers, to his injuries. Thereafter, Millers, basing on the dying declaration, which he is alleged to have made before his relations, which has been disbelieved by the trial court, investigation commenced, and 3 eyewitnesses have been examined, out of whom PW 9,
13 and 9.
Hemlata Sahu is one, PW 13 Chittaranjan Sahu is one. PW 9 Hemlata Sahu, PW 13 Chittaranjan Sahu, and PW 19 Prakash Kumar Singh. They are the eyewitnesses who were examined at a belated stage, Millers. And on the basis of these statements of the eyewitnesses, the trial court has been pleased to.
Dying declaration has been disbelieved.
That has been disbelieved.
So, what these witnesses have stated, these 9 about the role played by these appellants.
My lords, just
let us come to one eyewitness, PW 9.
Yes, your lordship may see PW 9 in the paper book. He is at page 291. My lords may look at page 291, first paragraph. Deceased Kesab Behra was known to me. I know informant of this case, Kishore. He is the brother of the deceased. I know the accused who are standing in the dock. Deceased Keshav died 3 days prior to Rath Yatra last year in the month of Asad. On that day, in between 7:30 to 8 a.m., near Debighar Chak, occurrence took place. At that time, while I was going to Lalamat from my house, taking flowers through Debighar Chak, I saw deceased Keshav coming on a scooter from Chandi Mandir side towards Debighar. After crossing me, I found deceased Keshav was being followed by 6 persons on 3 motorcycles. Immediately thereafter, I heard sound of firing bullets, and while I turned to my back, saw that a motorcycle was being driven by accused Jani. This is the deceased accused. And accused Bhelar was sitting on that motorcycle as a pillion rider, holding a pistol. Another motorcycle was being driven by accused Tony, and on that motorcycle, accused Montu was sitting as a pillion rider holding pistol. On the last motorcycle, Accused Rahul was sitting as a pillion rider, holding a pistol, and it was being driven by accused Littu. And all the pillion riders, namely Velar, Montu, and Rahul, were firing bullets from their pistols, aiming at deceased Keshav. After sustaining bullet injuries, the deceased went towards his old parental house on his scooter. After shot firing the bullets, all the 6 above named accused again returned towards Chandi Mandir and went away. Seeing the incident, I became frightened, returned back to my home through Lalamat. I have been examined by police in connection with the present case after 15 to 20 days of the occurrence. After the incident, I suffered from fever, recovered after 15 to 20 days. After recovery, I disclosed the incident before Basanta Behera, brother of the deceased. I reside with my husband who is blind and deaf.
So cause of death is also on account of firearm?
Yes.
Okay. So,
but there is no ballistic evidence on both. They have been acquitted of the charge under the Arms Act.
Arms Act. But this this criminal antecedent which has been pointed out by the Land and Council for the state,
Milords.
13 years it's all right, but how many cases are there against each of you?
Antecedents, Milords, they will pale into insignificance if your lordship will call for the criminal antecedents of the deceased himself.
No, that does not give you right to...
No, we don't say that, Milords. But what I say is, if your lordship will look at the antecedents which have been filed, so far as number 4 is concerned, there are 8 antecedents. My lords may look at the affidavit.
Where is the affidavit filed? Appellant number.
That is affidavit of Pakija Begum, dated 18/7.
Pakija Begum. That is petition, yes.
My lords, page 2, your lordship may see, I have given a serial of the cases against me. The first is Cantonment PS case 94 of 2010, 294, 307, 506 by 34 IPC, where I was on bail. Second is PS case 41 of 2011.
They have been acquitted of
Yes.
all these cases.
Third case, I have been acquitted. Fourth case, I have been acquitted. In the fifth case, a criminal appeal is pending. This is present appeal.
302 means this case or another?
Yes, this case.
Achha.
Then Cantonment PS 9 of 2013, I have been acquitted. Then Cantonment PS 31 of 13, I have been acquitted. And there is a 110 proceeding had been initiated against me.
Okay. What is the age of this man now? Person number 4.
Petition appellant number 4, just checking from the accused statement.
23 years when you prefer the appeal.
34.
What about the others?
Appellant number 1 is concerned with 2 cases there. I have given the debit that he is acquitted in 1 case.
Appellant number 1 means what is it?
Velar.
Ah.
He has given affidavit shown by his wife, my lord. In that affidavit, the state has pointed out 2 cases against me. State has pointed out 2 cases, my lord. One is that cases, my lord, is ended in acquittal, and another case is also I am on bail.
And then others,
my lord,
2, 3.
For 2, 3. 3 has no antecedent except this case.
3.
My lord.
Devraj.
My lord. And so far as 2 is concerned, present case and inside this case, another my lord Puri at 73 of 2012 is on bail, and another Malgotham PS case 84 of 2012 has been acquitted, my lord. And another Cantonment PS case 1 of 2012 is released on bail. Another case, Cantonment PS case 2 of 2012 is acquitted.
Yes, Mr. Counsel for the
There is one thing, my lords, I'd like to say. So far as the prayer for bail of the appellant number 4 is concerned, it's interim bail, my lords. For the illness of his mother, we have asked for. The other aspect your lordship will bear in mind is that there is direction for this appeal to be heard. It was heard in fact extenso, but hearing could not be completed, for which it has been lying. Otherwise, my lords, there is no latches on the part of the appellants for the
No, yes, paper
delay.
has also been prepared.
A matter of 2015 minal let me be listed in hearing matter.
No, he said that it was also heard before by
Yes.
some other bench, but it could not be completed. They are now for bail because they have in custody for 13 years. That is
I
the
would,
main
yes,
law.
well, that would, I will take instruction from the IAC whether if they will release, there is law and order situation.
That was called for my lord.
No, that is not called.
That was earlier your lordship directed that report was with
Just a minute. I think there was, he's right. Some order was passed in that light. Perhaps you see. That the order is there in 15/5/2024. We have mentioned Learned Counsel for the state shall obtain instruction if there is any chance of law and order situation in case appellants number 1 to 4 are released on bail. So this is already.
Come next week, I will see.
କୁନାହାନ୍ତି instruction ଆସିଥିବ ଆପଣ
ନାଇଁ
ଦେଖିଲେ
ଆସିନି ମୁଁ ଦେଖିଛି ସେଥିପାଇଁ ମୁଁ କହିଲି ନା.
No, it's from Lalbagh police station.
Yes,
you
sir.
can
Let
get it
come day
during
after
this
tomorrow.
week. Day after tomorrow, it can be obtained.
Thursday.
Mr. Mahapatra, anything you want to say?
Both the interim bail or the bail as it may be proposed.
Yeah.
I oppose it because your lordship has gone through the manner in which the crime was committed. It was committed in the Chandimandir road, just like in a film manner. And all the 6 accused persons, they followed the deceased and opened the fire, and ultimately death was caused. And one of the accused who was shown as absconder, still facing trial. In the presence of this appellant, if released on the interim bail even if for some period, that trial may be affected because he remains absconding for considerable period. This is one aspect. Second aspect, your lordship.
That trial is going on now. Okay. What is the name of that accused?
John.
Acha.
And the second aspect of the matter, your lordship may take the judicial note of the fact in the month of September, the Parvana Riti commenced the Ganesh Puja and followed by all other pujas. So nowadays, most of the having criminals, they are lodged in the jail, either convicted or facing trial. That's why we are living peacefully in court of town. At least my experience, if these fellows will be releasing even if interim bail, they will create havoc. Second thing is that my friend says for interim bail, I'm just pointing out in the year 2016, my friend filed some medical documents in support of releasing him in interim bail. And it was found on inquiry those documents were fake documents, and ultimately that was not fake.
Annexure 4. Appellant number 4.
4.
Yeah.
These are the modus operandi
Since paperwork is ready, I am suggesting one thing. If they have a case, they will be acquitted. It may be hard, a date be fixed, the matter may finally hard. So,
We'll see. You take instruction about the by day after tomorrow. We'll take up this matter day after tomorrow.
May I suggest one more thing? Since my learned senior is saying that the trial of the absconder is on, a report can be called for from that ADJ at Cuttack as to what is the status and whether any eyewitnesses remain to be examined. These are the three eyewitnesses. My instruction is probably they have all been examined. So, if that report comes,
So, you first obtain that instruction.
Yes, that is local court at Cuttack. So that report
A number for the Lavanatar case number came number.
I'll supply that number to your lordship.
Number the accused na we are after all we are taking up this matter day after tomorrow. Okay. अच्छा आज एटा जोटा फाइल कले एटा रेकॉर्ड रखी देथान है ना that किसी order खाली day after tomorrow को रखतान that means on 31st.
And the other apprehension of my learned friend, now there is a new government, new leadership, new law and order.
Okay. We'll see that. Yes, next.
Do you think that I will take care of the law and order of the town?
Yesterday we have seen in the newspaper your photograph.
Yes.
Item 11.
Item 11, Mr. Rautray.
This is the last order dated 23/7/24 Millard. 23/7/24 in IN number, in this case number 1152/15. The instruction was sought for regarding criminal antecedent of the this petitioner.
Not received the instruction. On 25/7 we have sent the letter. Let it come next week.
7 order is
ଚିଠି ଯାଇଛି 25 ସାତରେ
custody ଅଛି 27/9/2012 Millard.
Custody certificate ପଳେଇ ଆସିଛି
ନା custody certificate
ମଗାଇ ନଥିଲେ.
Okay, this case number 1152 of 2015. This is an application for bail. London Council for the State submits that the matter may be taken up next week in order to obtain the custody certificate. So also instruction regarding criminal antecedent, if any, against the petitioner. Put up this matter in the week commencing from 5th August 2024. Yes.
Honorable Judge.
Item 12.
Please, your lordship. Here the petitioner is in custody since 20th of June 2007.
20th of June
2007.
Yes.
The main accused in this case, my lords, his appeal has abated.
Okay.
And so far as this petitioner is concerned,
earlier your bail application was rejected, Mr. Panda.
My lord, so far as I was not appearing earlier, so I am not.
Let us go through that record. Admit hella. Tapore. Nahi, hey nikar. Okay. What is the prosecution case?
Prosecution case, my lords, is that an FIR was lodged at Saidnagar by one Rasmi Ranjan by the brother-in-law of one Rasmi Ranjan Mahapatra, alleging that his brother-in-law had left his house on 27/5/2007 and was proceeding to Bhubaneswar in an Innova with his driver Navaghan Mahanta. And at 2:30 p.m., when he tried to contact his brother-in-law, he asked him not to wait as he was at a long distance and the phone was switched off. At 11 p.m., a phone call was received by the elder brother of the deceased, about his abduction from Bhubaneswar and demand of 2 crores. And thereafter, my lords, another phone call came to his land phone asking him to arrange money. Since he could not be traced, FIR was lodged and a case under 364A IPC was registered. Now, in course of investigation, the IIC Saidnagar, who was investigating into the matter, got information from the GRPS Dhanbad about 2 unidentified dead bodies having been found. Now, these bodies were identified. One of them was identified as the driver's body. The other one could not be identified. And cause of death was found to be due to gunshot injuries, my lords. The remains were sent for DNA identification, and the DNA identification allegedly confirmed that it was that of Rasmi Ranjan. Now, those unknown numbers, my lords, from which phone calls had been made, that was identified by one Pradeep as being that of the petitioners. And the case turned to 1 under 302, 201, read with 34, and 25 and 27 of the Arms Act. So I was arrested on 26, 2007 at Jharsuguda. I made a confession on 24, 6, 2007. And on the basis of that confession, my lords, the case against me is that I had abducted and handed over the abducted person to other co-accused for the purpose of extortion. Thereafter, my lords, extortion was demanded and another FIR was registered. That is somewhere at Balangir town, my lords. That was when money was found to have been paid to the co-accused, my lords, Sheikh Haidar's associates, by a lawyer who is still absconding, my lords. So both cases have been tried together, and in the meanwhile, Haidar has died, my lords, because of encounter. And so far as the petitioner is concerned, he is in custody. There is one Ganpati Rai is in custody who was apprehended while receiving money. And one Jajati Biswal is in custody for having taken money.
So it is a case based on circumstantial evidence. So what are the circumstances, if we ask you?
Now, so far as this petitioner is concerned, the sole circumstance is his confession, my lords, and that the phones were traced to him.
Confession means
he made a confession before the police.
Police.
That is the only thing.
That is not under section 27. Anything was required?
No, nothing has been required.
You are in that CRLA 622 of 2015.
My lord.
This Julu alias Raja,
my lord,
is the sole appellant in that?
Yes.
He is a local man.
He is a local man.
Mr. Tripathi?
Yes, my lord.
Is it a case based on circumstantial evidence?
That is discussed in 100 page 102, my lord, of paper book.
Paragraph?
Paragraph 1. Paper book.
The paper book. 101.
102.
Para 41.
Para 41, yes.
Yes. No, about this particular accused.
Accused is
that is page 105, my lords.
105.
Circumstance number 3.
Acha. The involvement of Julu in the case is strengthened through the mouth.
Well, I am placing it. Through the mouth of one of his friends, examined as PW31, who was staying at Bombay at the relevant time. This witness is cousin of accused Benu, a friend of Julu who has been charge sheeted in this case and absconding till now. He admitted that Zulu visited him at Mumbai in the month of June 2007. Witness having been declared hostile was cross-examined and contradictions brought out from his mouth are confronted to the IO PW30, who stated that during his examination of PW31 at Bombay, he admitted that Julu met him at Bombay, requested him to advance some loan to start business there. Julu also confessed before him that he committed a blunder by handing over one of his friend and his driver to the associates of Sheikh Haidar for the purpose of money. Abductors demanded rupees 2 crores and thereafter murdered his friend and his driver. It appears he resiled from his previous statement to help his friend Julu. Then circumstance number 4. The next circumstance in support of the prosecution is the call detail report obtained by the IO shows that Julu was making regular contact with Rasmi before his abduction and on the very day of occurrence, which creates suspicion of involvement of Julu in the case. Next circumstance, my lords, is page 106. Circumstance number 6. Julu and his driver during investigation gave recovery of the vehicles used for bringing the associates of Haidar from Cuttack to Bhubaneswar, particularly the Indigo car, being a stolen property from Calcutta used by the abductors, is an additional circumstance against accused persons. Then page 107, circumstance number 12. Statement of PW15, a resident of Jagannath Vihar, before the IO, that on the relevant day of abduction, an Innova car and an Indigo car were parking in front of the rented house of Julu at about 2 p.m. and 6 to 7 persons leaving the spot, boarding the Innova, raise a strong suspicion regarding involvement of Julu and his driver in the case. Now, there is no TI parade to that effect.
Okay.
And next, my lords.
Any criminal antecedent against this man?
That has not.
He is in, as Mr. Panda says, he is in custody for 16, 17 years have already passed.
Yes.
I have filed an affidavit showing that I am in custody throughout the trial, never released on bail. I have filed a custody certificate also to that, with that affidavit. Affidavit dated 2011-2023.
Custody certificate আছে. 16 years.
Yes.
16 years, 4 months, 19 days. That is in 23. 17/11/2023 ର prisoner officer ଦେଇଛନ୍ତି.
Page 133 of the paper book, if my lords will look. The trial judge has given reasons as to why he is convicting me. ହୋମ କରିଦେଇଛି ସେଇଟା ତ ସେଠି ଥୁଆ ହେଇଛି ତଳେ ଆମ ଘର ଯୋଉଟା ଆମ ଫାଇଲ ଥୁଆ ହୁଏ ସୁଇଚ ବୋର୍ଡ ତଳେ
So we are granting him interim bail some period and watching his conduct.
Yes.
If it is found to be okay, then we'll consider. Mr. Devasis Panda, Land Counsel for the petitioner, submits that the petitioner was taken into judicial custody on 26/2007, and as such he has remained in custody for more than 17 years. The custody certificate which is annexed to the interim application.
Annexed to the affidavit dated
Affidavit dated 2011-2023 issued by the DPO cum Prison Welfare Officer Subjail Limapada also indicates that the appellant has undergone 16 years, 4 months, 19 days of imprisonment, including the under trial period as on 17/11/2023. The Land Council for the state has failed to bring on record any criminal antecedent against the petitioner. However, oppose the prayer for bail, considering the submission made by the. This is Mr. Panda. Which is your bail application? IA number?
IA number 1571 of 2024.
Then which are the other application? How many appellants are there here?
Here, 600.
Then why other applicants?
622, there is a single appellant. He had filed another application for bail in 2015.
That is to be not pressed, no?
Yes,
Miss
that
case
is
number,
to be not.
Miss case number 1704
4 of 2015.
It is not pressed. No? Then this oppose the prayer for bail considering the submission made by the Land Council and so, while not inclining to release the petitioner on bail, we direct the petitioner to be released on bail for 1 month from the date of release, and he shall appear before the inspector in charge of police station.
Saidnagar.
Saidnagar.
Saidnagar रे केस ହେଇଛି ନା?
नहीं ଆପଣ ଘର ଲୋକାଲ କୁ ଯିବେ ନା?
Saidnagar ରେ ଆଉ better.
अच्छा all right, the Saidnagar IAC of Saidnagar police station once in every week, that is on a Sunday, in between 10 to 4, and the IAC of Saidnagar police station shall submit a report regarding the conduct of the petitioner during this period of 1 month. Matter to be listed gote mas pore rakhidiyantu, he will file the surrender certificate. Okay, and stay realization of fine allowed, huh? Yes.
May I pray for a urgent copy?
Yes, sir.
Item 13.
May I please?
This is with relation to CRL choice. Yes.
May I please? The present petition matter custody since 24/3/2013, near about to 11 years and 4 months.
24/8/2000?
24/3/2013, my lord. And near about to 11 years and 4 months. Out of them, he has granted 2 months of interim bail, my lord. And he also surrendered in time.
No, you are moving in which one?
My lord.
Kasi?
Kasi, my lord.
Okay.
652, my lord.
So why it was adjourned to today?
Lord, the one IA for bail, my lord, interim bail.
Okay. No, earlier you were granted interim bail.
Yes, my lord.
For 8 weeks.
8 weeks.
Okay.
Can I have a glance the order dated 3/7/23?
3/7/23?
Yes, my lord.
It
is for court.
You can have ancillary.
Hey, 3/7/23 order.
Also about
3/7/23. Paper books have already prepared. It is for the lawyers to collect them. Land Council so and so state that he will collect the paper book. After obtaining the bail, the appellant was taken back the papers. Clearly, the appellant is trying to avoid the court. Cancel the bail order. That is CRLA number 375.
375 already.
CRLA 652.
That is for the other accused. So that order, Mr.
Yes, sir.
That was the order in respect of the other accused. That is, he is not appearing for that 375. He is appearing for 652 of 2015. And 11 years and odd is in custody. And what is the 8 weeks he has been granted bail. So you are not. Earlier he was granted bail for 8 weeks, na?
Yes, my lord.
By the order dated 10/3/23. So is there any instruction with you regarding
No.
misutile? No. Then are the Learned Counsel for the Petitioner Learned Counsel. This is CRLA number 652 of 2015, IA number 909 of 2017. This is an application for କୋଉଟା ଆପଣ ପ୍ରେସ୍ କରୁଛନ୍ତି?
Not please. That
Not
is
press. This is not press. 2017 not press କରିଦିଅନ୍ତୁ। ତାପରେ IA number 2140 of 22 stay realization of fine allowed। ତାପରେ ଯୋଉଟା ଅଛି IA number 1680 of 24 is an application for bail. Learned Counsel for the petitioner submits that the petitioner was taken into judicial custody on 24/3/2013 and he was not released on bail during trial.
no, my lord.
He was never released on bail during trial. However, however, he was granted interim bail for a period of 8 weeks by this court as per order dated 9/12/2022 in IN number 342 of 2021. And after availing the same, he surrendered at right time. The Learned Counsel further submits that since in spite of preparation of paper book, there is no chance of early hearing of the appeal. The bail application, the petitioner may be granted interim bail for some further period. Learned Counsel for the state opposed the prayer for bail. Considering the submission, the period of detention of the petitioner in judicial custody, and since the Learned Counsel for the state has not brought on record that the petitioner has misutilized his liberty while on interim bail granted by this court, keeping in view the principle laid down in the case of Letty, 3 months bail granted. Yes.
Please.
Item 14.
Who is it? Item number 14, who is there?
Lord, item number 14, I'm for appellant number 3 and 5.
It's all right. Why it has come? There is no IA for consideration.
Lord, as per noting, Lord.
What is the noting? Learned Counsel for the state seeks some time to obtain instruction regarding death of Acha.
Appellant number 1.
One Rupon Naik and Sujan Naik, appellant number 8. Oh, for that purpose it had come. Yes,
Yes, we have sought for the instruction, but not received yet. Let it come next week.
the Learned Counsel for the state seeks adjournment till next week to obtain instruction regarding the death of appellant number 1 Rupon Naik and appellant number 8 Sujan Naik. Put up this matter in the week commencing from 5th August 2024.
Item 15.
Please, Your Lords.
Well, the appellant is custody my lord 2010-2014. In the meantime, my lord, he was released on bail some days of parole by the CRLA number 639 of 2006.
639 of 2006, item number 15. 2004-17, Act 15, 721, the connected matter. Number of custody certificate of the owner also.
In the meantime, my lord, two of the co-accused released on bail by this one.
Mr. Have you obtained that custody certificate?
Yes, my lord, that is there. My lord.
What period is that?
That's those.
7 year certificate and criminal antecedent. Why? Two things. This is item number 15, yes. CRLA number 639 of 2016.
7 years, 6 months.
7 years, 6 months. देखिए who accused has been granted bail.
Yes, ma'am.
On verification found that there is no so for the question stands in a complete difference between imagining a driver is carried the victim as well as PW4 for some time in his auto rickshaw, a particular place. Thereafter, PW1 and PW4 are having a discussion beneath it. The occurrence in question took place. It was in dispute of the role activity he along with Mrs. Corporal, the boyfriend of the victim was been examined as treated. So what is your role?
My role is, my lord,
role is something different.
Yes, my lord. The petitioner came to the college of the victim and showing the picture on mobile and request him to go in the temple of Metakani. When the victim refused, he stated he went from the college. से कॉलेज को जाएगी ना तो वीडियो ये आई एम रीडिंग द 11% माय लॉर्ड
माने से घटना जगह रे नथिला
घटना जगह रे ही वाज प्रेजेंट
he recorded it
no my lord
how
he was at the time of college he was confessed that before the victim you recognize me then victim at the time of occurrence I was present and he cover his face by means of napkin my lord and went to the spot twice. And he returned and he went to the college after 2 months. Went to the college and showing the picture to the victim girl in his mobile phone. And request him to went to the temple of Metakan. When the victim denied, he left from the house and also threatened, if you are not went with me, I will.
Okay, that means you mean to say that the victim has not implicated this man in the commission of rape first.
No, mother.
Not even that he possibly took that man to the victim.
No, mother.
What is, yes, Mr. Where is that paragraph which you say?
Paragraph 6, my lord, PW1.
PW1 is the victim?
Yes, my lord.
The PW1 31.
Deposition copy not supplied.
PW1, I am the I can identify the accused. Yeah, na hala kono?
Prashant Donsena, my
Prashant Donsena. Prashant Donsena, he identified.
Yes, my lord.
Okay, then what role has been attributed?
I am reading the relevant portion, my lord. Para 7, my lord. Para 7 and 4 line after, my lord. I am reading, my lord. When I came out of the laboratory and about to go to my house, the accused, who on the very date of incident covered his face with a napkin, the identified accused Prashanta Donsena, came to me in between 12:30 to 1 p.m. He first asked me to identify him. When I told him that I failed to identify him,
He reminded the incident and told me that he was the said person present during the incident. He then requested me to join him at Metakani temple to offer some puja as my day are not going well. I refused his request and asked him to ask to why he is after me. On my refusal, the picture of sexual intercourse which was committed by the accused person taken on the cell phone was shown to me. When I asked him to ask to why he has kept his picture on his cell phone, then the accused Prasanta Ransana assured to delete the same if I would join him. I did not listen to him but proceeded to my home in another way.
2 to 3 days after, again he came.
2 to 3 days after, he again came to my college on the scheduled time in the between Etki and approached me about to avoid it. But I avoided.
That time also he came on the same time.
Yes, my lord.
Thereafter, he never disturbed me till I could know about the MMS. Oh, then the MMS was displayed. It was
made viral.
It was made viral thereafter. I found the video recording of the incident when I was subjected to it.
So, if this is the person, then you are present and recorded the.
No, recorded is the juvenile and the Vishnu Kisan. One by one committed rape, another person is recorded the mob.
No, there is no allegation, of course, you committed the rape.
Yes, ma'am.
But somebody recorded it, no? Then how it
one
came?
of the accused who is committed rape is recording the video.
You are not that person.
No, my lord, I am not recording.
So subsequently it came to your possession.
Yes, ma'am. That is my lord, paragraph 5 and 1, 2, 3, 5, 6 line, my lord. Paragraph 5. The accused Vishnu Kisan first committed rape on me and other was taking snap on his mobile. Similarly, after Vishnu Kisan committed rape on me, the other juvenile, Amir, committed rape on me. The accused Vishnu Kisan was shooting the picture on his cell phone.
Okay, so it is confined to two accused. One is that Vishnu Kishan and the other is
Amir,
who is a juvenile.
Yes.
And that means when the Vishnu Kishan juvenile recorded, juvenile committed rape, Vishnu Kishan reported. So it means it came to your possession and then which you are trying to utilize it. And you are in custody since Kebe to Gwele? 7 years, 6 months. Are the Learned Counsel for the petitioner, Learned Counsel for the state? The Learned Counsel for the petitioner submitted that the petitioner was taken into judicial custody since 2010-2014. However, the Learned Counsel for the state has obtained instruction that the appellant is in judicial custody for 7 years and 6 months. The Learned Counsel are referring to the paragraph number 7 and 8, wherein the role played by the petitioner has been deposed to by the victim herself, stated that the main role is attributed against two accused persons, namely Vishnu Kishan and another a juvenile, his name by name Amir na Amir. He further submits that the co-accused Munna Oram has been released on bail in CRL number 721 of 2016 as per order dated 27/6/2024, and therefore the bail application may be favorably considered. Land Counsel for the state oppose the prayer for bail. Considering the submission made by the Land Counsel for the respective parties, nature and gravity of the accusation, as per the statement of the victim, while not inclining to release the petitioner on bail on merit, but taking into account the period of detention in judicial custody, we are inclined to release the petitioner on interim bail for a period of 3 months. And while on interim bail, the petitioner shall not try to keep any contact with the victim or her family members, and shall not indulge in any criminal activities. Violation of any terms and conditions shall entail cancellation of bail. It will be taken up after 3 months. He has to file the surrender certificate. That is, this is item number 15, miss case number 1823 of 2017.
Yes.
And stay realization of fine allowed. Yes.
Item 16.
May be permitted to withdraw my application. In the meantime, he has been implicated in another criminal case and the trial has been commenced.
No. Criminal appeal, it is against conviction.
Yes, ma'am.
Why you want to withdraw the criminal appeal?
No, I'm permitted to withdraw my bail application.
Oh, bail application. IN number 1628 of 2017. There is an application for bail. The Land Counsel for the appellant seeks permission to withdraw the interim application disposed of as written.
Item 17.
Convicted under section 323, 302, 323 of IPC Miller, and is in custody since 22/11/2012.
That we have mentioned in the last order,
Okay, my lord.
but we asked
Lord
the
of
State
Disclosure.
Council to produce the custody certificate and to obtain instruction about the CA, if any. Yes, Mr.
Yes, my lord.
Item number
Yes, 17.
17,
655.
CRLA 655.
Sure.
କଣ 11 ବର୍ଷ କଣ 7 ବର୍ଷ ଲେଖା ହେଇଛି? 11 ବର୍ଷ କୋଉଠୁ ପାଇଲେ?
I mean, custody matter since 22/12/2012 matter.
12.
Proceed.
But ଏଠି ଲେଖା ହେଇଛି 15/15/9/2015 ରୁ।
No, madam, that is wrong.
ଆଉ କୋଉ
See
jail
the
change
date of arrest. See the date of FIR.
ଆଚ୍ଛା ଟିକେ ରୁହନ୍ତୁ, ଫାଇନାଲ ଫର୍ମରେ ଜଣା ପଡିଯିବ। ଇଏ ଦେଖିଲ ଫାଇନାଲ ଫର୍ମଟା। ନାଁଟା ହେଲା କଣ?
ବରୁ ଆଲେସ୍ ବରୁଣ।
ହଁ ଠିକ ଅଛି। ସେ ଅନ୍ୟ ଜେଲରେ ଥିଲା ବୋଧେ, ଏଇ ଜେଲରେ ଡାଟାଟା ଦେଇଛନ୍ତି, ସେଠୁ ମଗେଇନାହାନ୍ତି।
And within this period also, I have never gone interim bail, neither in interim nor in parole during pandemic.
22/12/2012. Accused is produced. Accused is produced in custody. All right. से ऑर्डर शीट तो पूरी पहले जाएंगे। ନାଇଁ ଏଇ କେସରେ ଏଇ କେସରେ ଅନ୍ୟ ଜେଲରେ ବୋଧେ ଥିଲା ଏଇଟା ଉଦଳା ସେଇଟା ହଉଛି ଇଏଟା ହଉଛି ପ୍ରଥମରେ ସେ ଥିଲା ଅର୍ଡର ସିଟ୍ ଯାହା ଦେଖଉଛି
That is a, I think my London senior has submitted a wrong because my name is Baruales Baruno Bahar. Here the name is Raghu Prusti. Raghu Purti.
627 though.
655.
Item
17.
ये तो अनुगुण किशोर ना
এটা সেটার আরোটা রাখি আইটেম নম্বর 16
Here the Raghu Purti.
You are right. You are right. সেটা accused না দেখিয়ে দিও
ବାରୁଣ ବଗା
ବାରୁ ଏଲିଆସ ବରୁଣ କୁମାର ପାଘାର ହଉଛି ଅନୁଗୁଳ
accused ଦେଖିନୁ ସେ
let it come next week custody certificate are not come
Latin counsel for the state seeks for an adjournment till next week to produce the custody certificates, also instruction regarding criminal antecedent, if any, against the petitioner. List this matter will be commencing from 5th of August 2024.
Item 18.
Supreme Court ର stay ଥିଲା ବାଟ ଏ ପାଇଁ କଣ କିଛି update ଥିଲା ନା We have mentioned also in order dated 9/2/24. London Council for the State produced the order dated so passed by the Honorable Supreme Court in so, from which it reveals that notice has been issued to the petitioner and operation of the implementation of the impugned judgment has been stayed. So what happened in the update matter? What order was passed for which state approached the Honorable Supreme Court? And the state not approved. State approved matter. State approved. State approved. That is matter. They filed a contempt application. Right. That is for the matter page 19 matter. Okay, there was this is matter relating to that home guard. And direction was issued that he has to be given engagement with regular wages and paid back the back wages for the period. Say most likely that was not carried out. Contempt. Whenever hear that opposite party reinstated. अच्छा for comply तार धीरे order pass ହେଇଛି ବୋଧେ କିଛି since it would have given a clarity ତା ଗୋଟେ ତା ଆଗରୁ contempt ହେଇଥିଲା 1099/2014 ସେଥିରେ state government ଇଏ କରିଛି ଯେ comply ହେଇଛୁ କଣ କରିବୁ therefore the order of this court has already been complied with. No, what was the order about? Earlier order. Anyway, this order is under challenge. Even if in 6/11 on 6/11/23 we have mentioned it is little elaborately that you submitted that judgment and order was passed in WPC number so and so. It was confirmed in writ appeal, and then State of Orissa approached the Supreme Court, and the you gave the number, but you and also said that the implementation of the impugned judgment has been stayed. So, but thereafter you have no instruction. Okay, non-obvious for the petitioner. Learned counsel for the state submits that he may be given some more time to obtain instruction regarding the status of specially petition civil diary number 38701 of 2023. এটা 9 to 24 order mention is a number. Which was filed by the state of Odisha and the matter may be खाली time नहीं तापर गोटे time दियंतु तांको 4 weeks परे ताको रखियंतु है ना the learned counsel for the state on the next day the learned counsel for the state shall apprise this court about the status of this है ना yeah
Item 19.
May I please, my lord, in this case, appellant has been convicted for life for offense under section 302 and 506. He is in custody since 8/2/2017. Case is based upon circumstance.
केते
8/2/2017. 8/2/2017.
For offense under section
302 and 506, my lord.
Case is based on circumstantial
evidences.
What are the circumstances?
Circumstances is that PW1 has lodged a FIR that on the 7/2/2017.
Circumstance कौन ना वो PW1 law.
से कौच जे बाड़ौथला 7 तारीख
They are husband and wife, madam. Husband and wife. This is the wife. And appellant is the husband. They are living together. One of the one has seen deceased and accused quarreling and assaulting each other in the evening hour.
8 p.m.
On the next day morning, the
she
deceased was found dead.
Hmm.
Witnesses have seen the accused in the company of the deceased till late in the night. Deceased has died homicidal death. This accused has not explained as to how and under what circumstances his wife sustained bleeding injuries. The accused has tried to misdirect the investigation by lodging a report with false facts. He himself lodged the report. The accused threatened PW1 to murder when she tried to pacify him while quarreling and assaulting the deceased.
So for PW8 is concerned, he is the son of the appellant and the deceased. He was about 14 years. He has stated that they were not in good term with that PW1.
He turned hostile.
And so far PW5 is concerned, the father of the appellant, and he was inside the house also. The dead body has not been found from the house, but from the under the veranda, where as per the witnesses' evidences, the PW5 was sleeping. No, it is honoringly, it is not pointed out that no other than the accused has committed the crime.
କେତେ ବର୍ଷ ରହିଲେଣି 7 ବର୍ଷ
7 ବର୍ଷ 5 ମାସ 21 ଦିନ as on today, my lord.
କେବେକାର appeal ଏଟା
Of 2018.
Are the learned counsel for the petitioner, learned counsel for the state. The learned counsel for the petitioner submit that the petitioner is in judicial custody since 8/2/2017. case is based on circumstantial evidence. There is no chance of early hearing of the appeal in the near future as paper book has not been prepared, and therefore the bail application may be favorably considered. Learned counsel for the state, on the other hand, opposed the prayer for bail and argued that the petitioner is the husband of the deceased, and he was seen assaulting the deceased by some witnesses, and the dead body of the deceased was found in the house of the appellant, and the doctor bracketed PW7 noticed injury on the skull of the deceased and opined that the cause of death was due to hemorrhagic and neurogenic shock resulting from the injury to the skull. After hearing the learned counsel for the respective parties, nature of evidence available on record, particularly the postmortem report finding, while not intending to release the petitioner on bail on merit, but taking into account the period of detention in judicial custody and keeping in view the ratio letdown in the case of Letty, we are inclined to release the petitioner on interim bail for a period of 3 months. While on interim bail, he shall not indulge in any criminal activities. Violation of any terms and conditions shall entail cancellation of bail. This CRLA for you out আছে IN number 3163 of 23. এটা কোন interim bail কোন?
সেটা not press করছে
আচ্ছা, not
interim.
press, এটা not press করছেন। মেন বেলটারে যেটা 2018 হলো সেটারে bail granted for 3 months.
That is IN number 1584 of
Right.
2008.
Yes.
Obliged.
Item 20.
Mr. Pradeep Kumar Pradhan. Not there. Yes, next.
Item 21.
In this case, conviction is based under section 376B.
But there are two criminal appeals.
My lord.
1 minute, 288.
You are appearing for
288.
Sanjay Naik. You are appearing for Loknath.
My lord.
Okay.
I prefer let it come day after tomorrow so that.
Okay. Day after tomorrow means 31.
My lord.
31/7/2024. Okay.
Obviously.
Booklet number 288.
আবার হ্যাঁ 288 রকি দিতাম সেই দিন অর্ডর করিয়া পর দিন সিল মারি রকম
Weekly দিয়ে আছে তো
হ্যাঁ
weekly
হ্যাঁ হ্যাঁ এইটি রইলা ডকা জিও
Item 22.
Yes.
My lord. Last time your lordships sought for some instruction, lordships,
What instruction?
regarding the eyewitness status and the CA of the accused.
Learned counsel, however, submit that as per the said order, he is to produce the status of sole eyewitness, PW11, and he may be given some further time.
And
PW11 ki?
the eyewitness, the granddaughter of the deceased man.
Acha.
Simple.
এটা কোন এই কেস না আর একটা কেস Acha, another case.
CA is another case.
Dharani Munda.
Yes.
31 of 2000. The case has been closed and the CS has been submitted. Acha. Namu, same case is one. Telco EPS case number 31 of the Kiro judgment. ନାଇଁ ଏଇଟା ଅଲଗା କେସ୍ ଏଇଟା ହଉଛି 41 ଏଇଟା ହଉଛି 30 ଏଇଟା 2010 ର ଗୋଟେ କେସଟା ମାଷ୍ଟର ଡେଭଲପମେଣ୍ଟ ଫର ଦ ରାଇଟ୍ ଅନ୍ PW11 Swan Su daughter of Swan Su ଆଚ୍ଛା ବାହା ହେଇଗଲାଣି ସେ ଝିଅ after completion of some ଏଇଟା ହଉଛି ସେ ଯୋଉ ଝିଅଟି ହଉଛି ଆର ଆକ୍ୟୁଜଡ ହଉଛି ତା ମାମୁଁ ଆଉ ଇଏ ହଉଛି ତାର ଆଈ କିନ୍ତୁ ସେ ମାମୁଁ ଘରେ ରହୁଥିଲା ଇନସିଡେଣ୍ଟ ହେଲା ଝିଅଟି ବାହା ହେଇଗଲାଣି What is your period of detention?
9 years, 3 months.
Oh, 3/5/2015 କଷ୍ଟଡି ଗଲା ଆପଣ କଣ ସେଇଦିନ କଷ୍ଟଡି ପଳେଇଲେ ନା ଏ ଫାଇନାଲ ଫର୍ମ ଟା ଦେଖିଲେ ହଁ 4/5 ରେ ଆପଣ ଗଲେ 4/5/2015 and you are never released on bail accused is produced in custody no okay so 2015 ମାନେ 9 ବର୍ଷ 2 ମାସ 9 ବର୍ଷ 2 ମାସ are the Learned Counsel for the petitioner, Learned Counsel for the state, in pursuance of the order dated with the last order 16/7/2024, the Learned Counsel for the state has produced the status of the sole eyewitness bracket PW11, which indicates that she has already got married. The written instruction is taken on record. Learned Counsel for the petitioner submit that the petitioner is in judicial custody since 4/5/2015 and the and paper book has not been prepared and therefore there is no chance of early hearing of the appeal in the near future and the balance of convenience is in favor of the petitioner and therefore the bail application may be favorably considered. Learned Counsel for the state opposed the prayer for bail and submitted that the sole eyewitness has stated how the appellant dealt axe blow on the neck of the deceased was none else than his mother, as a result of which the deceased died. She also placed the evidence of the doctor, bracketed PW 14, who has stated that the cause of death was due to excess hemorrhage caused by incision of major vessels and incision of spinal cord. And injuries on the dead body of the deceased were sufficient in ordinary course of nature to cause death. In view of the available material on record and the nature and gravity of the accusation, while not inclining to release the petitioner on bail on merit, but taking into account the period of retention of the petitioner in judicial custody and absence of any chance of early hearing, we are inclined, keeping in view the Letty case, 3 months bail granted, date to be fixed for surrender and conduct report be called for from the IAC, and he shall not indulge in any criminal activities. Violation shall entail cancellation of bail. Yes.
Item 23.
Criminals call for the information from the concerned jail matter. The period for detention in custody. Let's call for that information.
23/7/2024.
Yes.
Plan and Counsel for the state submitted that he has received the custody certificate in so sought for obtaining the custody certificate of Santosh Maharana.
Yes. Mine is Santosh Maharana.
Plan Counsel appellant submit that he had already supplied the bail order copy of the co-accused persons to the Land Counsel for the state to examine the claim of parity.
Yes.
Mr. H.S. Mr. Land Counsel for the informant is present. State Counsel submits that so if any again the appellant in both the appeals. Yes, sir. So first of all the custody certificate and
Both the appellant's certificate.
Yes. Name of the prisoner Santosh Maharana. CRLS sauce on chart. Total period होची 1834 दिन. केते हला हिसाब कला
9 वर्ष दिन हो.
बहुत दीटा मिसला को 9 वर्ष दिन होची तो टोटल पैरेलल पीरियड 268 डेज.
पैरेलल पीरियड पर काटी किने आपण हिसाब करछन पुनी को. पैरेलल पीरियड काटी किने हिसाब करछन. पैरेलल पीरियड होची 268 दिन.
68 दिन. 9 वर्ष.
अच्छा तब 18टा
10 months, 10 years, 5 months, 20
10 years.
Your Lordship had also called for that antecedent.
Antecedent, super antecedent, my lord. I had given, my lord. Verified available High Court PS record found nothing any criminal antecedent except this case.
Okay.
Super High Court PS
May I submit matters? One small submission. Here in this case, matters 5 accused persons, 5 appellants, 5 criminal appeals. Matters that judgment is there. Matters kind of a minute. Matters kind of a glance to that judgment, copy of the judgment.
Let us not certain about the antecedent. What the order let us.
Let me place it there after antecedent. Matters can anytime.
We'll hear, Mr. Everybody will hear. Just we are not in a hurry.
No, your Lordship wanted that to antecedent.
So,
that is what I say. That is wrong. There are 4 cases. While on parole, he committed an offence. Overlapping.
Mr. Misra.
Overlapping only.
କୋଉଠି 4 କେସ୍ ଦଉନାହାନ୍ତି ଆପଣ?
ଆମର ତା number ହଉଛି High Court PS case number 1.
No, just in writing if you give we can ask for
this is note that your Lordship can see.
ଆମକୁ ବି ଦିଅନ୍ତୁ ଟିକେ
ଟିକେ କାଇଁ ପୁରା ଦେବି ବହୁତ ଦେବି
এইটা ଯୋଉ ଆଣିଛନ୍ତି
ଏଇଟା
this
କଣ
is
ନା ଆଣ୍ଟିସିଡେଣ୍ଟ ବୋଲେ କେସ୍ ରେଜିଷ୍ଟର୍ଡ ହବା আগরটা ବୋধେ ଧରି
just a minute. This is from Khalikot police station.
Probably that is the thing, but the whole point is that he being the principal accused, this Santosh, he has committed a crime while he was on parole, and while in custody also he committed three cases where police have filed charges. That is my information. I have given the number. So
Wait. Why are you
getting impatient?
We are hearing everyone. Just a minute. During parole, the appellant committed a crime, so on. So Barampur Sadar PS case number, okay. Then another 3 petitioner has, that is
while in custody, and that charge sheet has been filed to my instruction. If your lordship will give me time, I can get the certificate copy, or my land friend get also the instruction
verify
whether that is true or not.
I will
नहीं ଆପଣଙ୍କର 3ଟା କେସ୍ ଯଦି
4ଟା total.
ନାଇଁ
3ଟା in custody. Custody taken as a conspirator probably. He has committed crime where charge sheet has been filed against him.
Khalikot ର ଥାନାର ଆପଣଙ୍କର ମିଷ୍ଟର ମିଶ୍ର ଏଟା କଣ affidavit ନା ଏଟା କଣ
ନା ମୋ note ମୋ ପାଇଁ ତିଆରି କରିଥିଲି
no you file it by way of an affidavit ଆପଣଙ୍କର informant ର ଗୋଟେ affidavit file କରିଥିଲେ in which you can just take that
I'm giving the number. You can get instruction, and I will also file collect the materials. And I will also collect the details of those cases.
Seal मार देले पटकिन
I thought that the IO will give that thing also along with this to be fair enough. But technically, antecedent means the dictionary says
prior to these things.
So very good.
So this is one part. So by the way, what is the prosecution case?
May submit my prosecution case is that one all the 5 circumstantial evidence, all the 5 committed murder murders. This is the allegation.
No, what are the circumstances?
One circumstances was some extrajudicial confession that one of them, the main conspirator is that appellant number 1.
No, one item of circumstantial evidence is extrajudicial confession.
Confession that when Samsundar Pusti was discussed, others were discussing to kill the deceased.
No, that is not extrajudicial confession.
No. That is one of the circumstances. He heard it and he told it. That is what that has been relied upon.
No, they are discussing to commit the crime. Then how can it be extrajudicial confession?
No, not extrajudicial confession. One part. This is another part.
Okay.
So, my humble.
It is a type of conspiracy.
It is a type of conspiracy.
Okay.
Type of conspiracy.
Then.
My humble content, these are the main things. The 2 things are main important things, and basing upon which these convictions. My humble contents are very simple manners. If please to go through the FIR. Well, best it goes to the root of the case. I'll have a glance to FIR first. Exhibit 14. Kind of a glance to Exhibit 14. That will speak about how a case has been subsequently modulated and a story has been created, and the petitions all have been brought into task. It's fair manners. Exhibit 14.
Very fatal.
May because the time is there. Now my learned friend senior submits that some antecedent. I will take instruction about that antecedent. One part manners. These part manners are submitting so far FIR.
No. One thing is that what Mr. Mishra is pointing out, if it is found to be correct, suppose you are going on parole and committing 4 offenses, it is not a
one case. On parole 1. One parole 1 and 3 while in custody.
While in custody, I don't know. So far parole is concerned.
ସେଇଥିପାଇଁ ପରା ସେ କହୁଛନ୍ତି ଆମେ ତାଙ୍କୁ କଣ କହୁଛୁ ଯେ ଆପଣ affidavit form ରେ ଦିଅନ୍ତୁ.
Yes, that exactly my said it. I also requested to solve this. I will take instruction in this.
Okay. He will ଏ ତାଙ୍କୁ ଦେଲେ ସେ ଯୋଉ ଆପଣ ଯୋଉ seal ଟା ମାରି ଦେଇଛନ୍ତି ନା ସେଇଟାକୁ ରଖିକି ଆର page ଟାକୁ ଦିଅନ୍ତୁ. He just put a seal. It cannot be handed over to you, but just
that will be part of the record.
Second page, you give the second
page ଟାକୁ ଦେଖେଇ ଦିଅନ୍ତୁ so that he will ତାକୁ ଜେରକ୍ସ କରିକି ଦେଇ ଦିଅନ୍ତୁ ସେକେଣ୍ଡ ପେଜ. କହୁଛନ୍ତି କାଉନସିଲ ଯେ ଏଇଟା ମୋର ପର୍ସନାଲ ନୋଟ ବୋଲି ଆପଣ ସିଲ୍ ମାରି ଦଉଛନ୍ତି ତା ଦେହରେ.
Another copy may be given.
No, he that is an incomplete note. He's saying that I'll file the affidavit. So all right, you take Mr. Lekhidantu, Learned Counsel for the state has produced the custody certificate of the appellants. Santosh Maharana as well as N. Ramesh alias Narayan Reddy, which are taken on record. है ना ये ला गोटे कथा ये जो एटा होची item number 23 ला Santosh Maharana in CRLA numbers 1 so and in Santosh Reddy. He has also produced written instruction received from IIC Khalikot police station dated 22/7/2024, which indicates that the appellants have got no criminal antecedents in Khalikot police station record. As per the Khalikot PS case record, the petitioners appellants have got no criminal antecedent. Mr. H.S. Misra, Learned Counsel, appearing for the informant, on the other hand, submitted that not only kiye crime kala di jana bhitru kiye Mr. Misra
The
Santosh Maharana.
The Santosh Maharana, while on parole, committed an offense for which a case was registered, and while he was inside jail custody, he committed 3 crimes for which 3 cases were instituted. He has furnished the case numbers of those cases not only to the Learned Counsel for the state but also to the Learned Counsel for the appellant in Santosh Maharana who want to obtain instruction on the same. The Learned Counsel for the informant also submits that he will file an affidavit of the informant relating to the same, relating to the criminal cases instituted against the appellant Santosh Maharana during parole as well as while in custody.
Parole, I know that one case and has been released on bail. So for other 3, I will petition.
Release on bail is not a material, Mr. Patro. Release on bail, you are gone on a parole and you will commit an offense while in custody. So that is not whether you go on bail or not. So put up this matter in the week commencing from 12th of August 2024. Both these matters will अच्छा ये order टा जो आपण mainly संतोष महाराणा को केस रे लिखि दियो कारण ता नारे मेन ये रोची तो हैला ता दिरे ता दिरे रेफर कर देबे ये करला बोली हैला 780
ये केस वाला
780 रे खाली लिख दियो तो कस्टडी सर्टिफिकेट फाइल हेची आ ता दिरे एंटीसीडेंट नाही आ बाकी तो जिंस आपण 649 ने इंडिकेट कर ए जोटा କହିଲେ ମିଷ୍ଟର ମିଶ୍ର କହିଲେ ଯୋଉ ତା ନାଁରେ ପ୍ୟାରୋଲରେ ଯୋଉ ଅଫେନ୍ସ ହେଇଛି ତାପରେ 3ଟା ସେଟା ତା ଦେଲେ
this is a case my lord.
The cases, yes.
Your lordship will find if you go through the record. This is one of the rarest, a case where there shall be a good investigation. Almost we see mechanical investigation. Apart from your lordship, remember that the case of Patnagar, that was also a rarest investigation. In true sense, it can be said to be, and this is the case. In the old, they started. If your lordship go through
what is the case actually? Prosecution case?
It's a conspiracy. What they thought that we are giving, but
conspiracy.
Exhibit 14 FIR.
No, कौन है जी कौन?
A case is that on 27/5/2014, my lord, while the PW19, along with the deceased, were my lord coming from Hollywood by one after 2 motorcycles back to back. Then my lord, the PW19 well seen that in the back deceased was not coming. Then he returned back. Then in focus of the my lord, in the light my lord, found that 3 persons were my lord shifting the dead body. Well, they are namely as Prabhakar Acharya, Millu alias Jitendra Acharya, brother-in-law Millu Acharya, along with my lord 3 others persons. FIR was lost against named persons, and the informant is none else than his elder brother. He identified these persons, my lord, but they have not been, my lord, charge sheeted.
They have not been charge sheeted.
That is why I am saying it is one of the rarest investigation. Rarest investigation.
Statement was
Ah,
recorded,
it's up-
and IO was examined. He has also stated that they have stated these particular 3 persons were shifting the debt. Then, my lord,
Shifted
the
three.
India report come back. Another IO came. They have also not even examined. They have not as a
Yep.
witness, and also even when added as an accused. They have been deleted from the charge sheet, and new story came. When another IO came, he stated that from the call details of the deceased, this is that some persons were calling to that number back. From that call details, they arrested P. Samsudar Prastika. He
And
confessed
others.
that we made a conspiracy to, because he has a cabbage factory, some child labor was working, and this is a journalist who was publishing for demanding some money.
Who was a journalist?
This is a journalist.
Acha.
She demanded some money because of to expose in the social media. That's why a confessional statement. P. Samsundar Kusti made a conspiracy to teach other appellants to commit murder. Thereafter, basing upon his statement, other appellants were arrested. This is the background.
Well, that is not correct. True, my lord.
Just
Truth is, my lord, I'm saying
let him complete. Let him
One by
complete.
one.
if there's
We're just know the prosecution
Madam.
case. We are not deciding because we have already adjourned the matter.
So far as my client is concerned, my lord, from the confessional statement to motorcycle was seized. That is also not the belonging to the accused person. Present feature that is for other accused person. Another conspiracy, my lord, one, my lord, another PW had been stated that while he was going to the cabbage factory, my lord, he saw that P. Samsundar Prushti was talking with two, three persons regarding some money. But he has not immediately not stated anything after few days.
Okay. Just no, we just are going through that charge sheet copy.
Yes.
It means in the last part it is mentioned that accused persons due to his personal vendetta hashed up a criminal conspiracy and murdered the deceased Tarun Acharya. And Tarun Acharya here mentioned that he was a reporter of some newspaper and a TV. He was the younger brother of the Swansu. He was engaged and published the news of child labor working in different cashew factory and the Swansu. Acha. Okay.
And
The main contention,
investigation.
may submit one line, my lord. Just a minute. Well, the whole total contention is that the younger brother has seen the dead body of the elder brother is thrown away by 3 persons, and he named the 3 persons. He named these 3 persons. These 3 persons, neither they have been cited as evidence, no, but initially FIR was filed against them, nor they have been brought into the evidence box. They were the best witness. They could have said that who has caused this crime, where from they got their dead body, why they were going to throw it. Now my learned senior says that there is a very good investigation and all the investigation revealed everything, but it touches to the very root of the case.
Yes.
If you lords permit me, I want to say something, my lord. Here, what happened, my lord?
Please. We have hardly just
Had it been a case like this, what that defense case would have been accepted. On the date of admission, they would have been released on bail.
No.
Why not?
Mr. Please, address to us. Yes. ଆପଣ କହୁନାହାନ୍ତି ଆପଣ
The over anxiety.
ଆପଣ କୁହନ୍ତୁ Mr. Please submit. Yes.
Here, the point is that though FIR was done, the FIR is not everything. FIR যদি যাহা কোয়া হয়েছে সেটা শত কনভিকশন ସବୁ কেস কনভিকশন। The FIR story was that, but the investigations is to find out the truth. And while going deep into the matter, when the matter was entrusted to crime branch, they found the detailed clinching evidence of the conspiracy that these 2 people were hired by that cashew nut owner because this man, the reporter, was intending the reporting the child labor use of that marine man. And they have got all connecting, the full connecting chain of conspiracy, murder. maybe little different than the FIR. FIR is not this everything. FIR is the first of all it gives a lot of material to proceed with the investigation.
Yeah.
But it is FIR is not the truth. What he says now, because the prosecution they found the investigation, the materials far beyond the FIR, they want to take advantage of the FIR. But the point is that if the law is that whatever the FIR is there, that is truth, that is something is different. The FIR leads to a case of homicide, which gives the right to police or to
put the law to
yes, to keep it in motion to find out the truth investigation, and they found out the truth in a detailed manner, which with my experience I can say the investigation has become a mockery in the virtually the whole of the
Tapan Acharya has been examined as PW
1990. So the whole point is that the nature of evidence they found, they are not saying they are evidence, they are saying that defense. The whole point is that the nature of the evidence will go, Lordship will go through it. The investigation done on the basis of the investigation done by the crime branch. I can, your Lordship will also experience from the record that this is not a usual investigation. A much of effort was given to find out the conspiracy, and they found out the transport has convicted everyone.
PW 19.
My lord, is an informant. Brother of the deceased.
Yes.
The entire investigation, the evidence is to be seen, not the FIR. Now, after the trial, FIR is not to be seen. The entire evidence is to be seen.
Just a minute.
कितने नंबर बिल एप्लीकेशन का यार संतोष का 10 वर्ष में फैक्टर ना 649 10 वर्ष भीतर थोड़े
he has also stated the same thing in the evidence that I saw that three persons they just in the evidence he has stated that as Tarun was not coming, I again returned towards Khalikot on my bike, and on the headlight of the bike I found that some persons throwing one near the excise office of Khalikot. On the focus of the headlight, those persons fled away. I went near the place and found my brother Taruno with several injuries, the neck. And at the scene, I ran towards my brother-in-law, and about 15 minutes thereafter, Smartso arrived. Then we shifted. So he has only seen a part of it.
Yes.
It is not that he is a eyewitness to the whatever both of you are telling. Is not that they were the eyewitnesses to the occurrence, seen the actual assault, that X, Y, Z were assaulting, and subsequently the version was changed. He has seen. Of course, he has named the person.
Yes.
Here he has stated that some persons were throwing the dead body. That's all. But the other things what has been transferred during course of investigation is perhaps the conspiracy part, the other part which you are highlighting, that extrajudicial confession. All these things came into fore because of this investigation. That is why Mr. Mishra is telling that FIR is not the encyclopedia. So he has seen a part of it, that somebody was throwing the dead body.
Exactly.
But who is the author of the crime, that came into fore during the course
Exactly,
of
my lord, my humble contention is this.
The Tarun was coming.
What happened, my lord?
Any, my lord, the case is being taken up for hearing, my lord, particular date, my lord, we will appraise it, my lord, how it has a relevance.
If they will shifted on 201, might be, but totally deleted from the charge sheet.
What?
That part will.
What I am saying, my lord.
Tarun was coming alone in a motorcycle or being a pillion rider.
No, alone.
Tarun is coming in the back.
In another way.
No.
In another way.
He was driving himself or
himself.
alone.
Alone.
And Tapan Acharya is the elder brother.
Yes.
He was coming in the front.
My lord, we all know that each and every time, my lord, each and every time left his footprints, my lord. Here, my lord, the mobile phone, my lord, the disease, my lord, many things, my lord, created, my lord. That mobile thing and the CDR report and the tower report and the conspiracy, my lord, came, my lord. Samasundar arrested on basis of the, my lord, contact number of the deceased, my lord. The mobile seized from the dead body
and that mobile my lord leads the entire investigation, my lord, entire case, my lord. And the mobile phone which used, my lord, last time call from the accused Samsundar, my lord. Then the Samsundar, my lord, he is having a cashew nut field, my lord, cashew nut factory, my lord. See, Samsundar engaged some child laborers. The deceased, my lord, taken photograph and published it in the, my lord, newspaper, Connaught News.
That we have seen that.
My lord.
The
For that reason, my lord,
motive behind the commission of the
my lord,
crime
my lord,
is this.
motive is very clear, my lord.
And all that chain is established.
And Samsundar had given, my lord, rupees 50,000, my lord.
These two are the authors.
And that
They
50,000
are perhaps harping on this point that when 3 persons specifically named in the FIR who have been throwing the dead body, why they have not been charge sheeted? At least they should have been under 201 of the act.
201. Another aspect is also that.
Maybe that during course of investigation, during trial also, he has not named or maybe 161 statement with the ତାଙ୍କର କିଛି ଗୋଟେ ଅଲଗା ଟାଇପ ର କହିଥିବ ଯୋଉଥିପାଇଁ ଚାର୍ଜ ସିଟ୍ ହେଇନି.
That has been well
They have not been willing. They have not been willing.
That is not a reason, my lord. Speaking it,
Yeah.
also fixing it,
We are keeping it on 12, and you now you have got the numbers,
yes,
4 number. So get it
Yes, my lord.
an
Yes,
instruction.
yes.
And Mr. Ragad,
My lord.
when you are giving, suppose let us say it is coming from the Khalikot police station. So he is verifying the Khalikot police station records, and how he is submitting, if it is correct, the information.
Today morning also I have contacted him.
If the information which is supplied by the client of Mr. Mishra is correct, then how you are omitting those cases?
That is came to my mind because I was appearing for the informant in other criminal appeals. For that, then today morning I also asked the IO, while he was on parole, he has committed a crime. He stated that not that police station, that is Berhampur.
No, it's all right, but Khalikot police station Audita achi pura.
Exact for that reason, my lord, specifically, my lord, asked him. He will file affidavit, my lord.
That's all for today.
Right.